of Wednesday 27th of November 2013. I'd like to remind everyone present that this meeting will be recorded and that the recording will be subsequently made available for public listening. Do we have Sederunt and Apologies, please?
The meeting did probably called in as quota. We have apologies from Councillor Peter Dickel. Is there any other apologies?
Thank you. Declarations of interest. Councillor Dick.
Thanks, Chair. Item 13, business interest.
Thank you. Any other declarations of interest? Councillor Carruthers. Thank you for that, Councillor Carruthers. Item 5. Item 5. No, for Councillor Carruthers. It's not item 4. Item 5, Ian. Alistair, do you have any declarations of interest? Thank you. 5, okay. That's all. Okay. Minute of meeting of 23rd of October. Are members content that's a true record? Thank you. In that case, we'll go to item 4. Pardon? Oh, sorry. I haven't allowed Paula to do her briefing first for members and members of the public. Sorry, Paula. Carry on.
The Planning Applications Committee will consider each application in turn as detailed on the agenda. The case officer or an area planning manager or other appointed officer will make a short statement addressing the determining issues accompanied by digital images. Any late information, amendments or corrections will be reported at this time. Members may ask questions of officers following the presentation on points of clarification. For those applications which are in accordance with Council policy subject to public speaking, then the order of eligible parties being heard will be as follows: third parties objecting to an application, third parties supporting an application, statutory consultees objecting to an application, elected members of Dumfries and Galloway Council who are not members of the Planning Applications Committee, and such members should withdraw from the committee chamber after making their presentation, applicants and their agents. The Chairman will individually invite those who have registered in advance to speak in respect of the application to come forward, sit in the reserved seat and make their presentation, after which they may be questioned by committee members. No questions may be asked of committee members. When each presentation is completed, people should immediately return to their seats. After all the representations have been heard, the meeting is then in formal session and no members of the public may address the committee from the public gallery. The Planning Applications Committee will then proceed to determine the application, or if the application is a major development significantly contrary to the development plan or a national development, agree a recommendation to be made to full council, who will determine the application. The decision notice will be issued after a period of 48 hours has passed. The Chairman has been provided with a list of eligible representatives who have registered in the period specified in Council policy. These individuals have all had their registration to speak confirmed and no other persons will be allowed to speak. Representatives have been placed in alphabetical order. A copy of the public speaking list is available from the committee officer taking notes of our proceedings. Representations on planning applications must be made on the basis of valid planning matters only. Certain matters are not normally material planning considerations and will not be taken into account by the Council when deciding on an application. Representatives are encouraged to use the time allotted to clarify any points they consider material and address the determining issues. Representatives should not raise any new matters without explaining why they were not raised earlier with the case officer. Please do not repeat what's in the report, as members will have already read the report. Presentations will be strictly limited to 3 minutes per person, excepting for national and major developments, which by their very nature are more complex, where the time limit will be 5 minutes. This should allow sufficient time for interested parties to make relevant points. The Chairman of the committee will ask you to come to a conclusion if you take too long.
Thank you, Paula. We now go to item 4, alterations and extension to hotel at Port Logan Inn, Port Logan. And members will recall that this is already in session. Only members that were present last time will be able to participate in the debate, or at least in a vote should a vote come to pass. Given that we're in session, we've already heard the applicant and we've heard the case officers. I think if members want a refresher on the the images that we had available the last time. Billy Murray could probably do that for us, and then we'll continue in session. Members are happy with that. I'll ask Billy just to quickly run through the images again, please.
Okay, thank you, Chair. I'll just quickly take you through the images. This is a view of the front elevation of the property, with, as you note, works already underway. Again, that's the front and northeastern gable elevations, street running along the front. This is a view from the south towards the southwestern elevation, showing the projection of the front extension. That's a more distant view from the same similar viewpoint on the street, looking generally northwards. That's the northeastern elevation, showing there's an extension to the front and down that side. This is the access to the service yard at the rear. Ground levels fall there, so the property is effectively higher at the back than it is at the front. This is a view of the rear elevation, again with works substantially underway in terms of the extension. Similar view of the rear elevation. An overview of the rear elevation looking southeast. That shows private gardens behind the terrace of houses in Port Logan. This is a view towards the rear site boundary. That's me standing with my back against the outside wall of the original property, looking towards the rear of the site. This is a general view of the street scene looking northeast in Port Logan. Slightly closer view zoomed in. A distant view from the southwest. Looking southwest. That's a view over the car park area on the opposite side of the street, looking towards the hotel itself. And again, from the same point, just a general view of the village. This is a closer view of the front elevation, showing the columns. There's much reference to those in the report and indeed in representations. Again, a closer view showing the front door detail as built at the moment. An interior view of the front tea room extension. An interior view of the side extension as existing. Side extension again from the rear looking forward. This is an image of the Port Logan Inn as it previously existed in 2011. And this is an overview of Port Logan Village as a whole, again taken in 2011. The following slides are all the plans that were submitted, and as members will recall from the previous meeting, they were a bit unsuccessful in terms of showing the difference between the approved development and now proposed. So unless there's any objection, I'll just whiz past these. We have one additional plan that was submitted by the agent following the site visit. He had produced a plan showing an overlay of the floor area, the footprint of the development as approved and as existing. So the blue line is the approved floor area, and the green line overlaying it is what is now proposed. I think, of course, it has to be said at this point that the floor area or the footprint is only one aspect of the changes. The real issue that the officers have in terms of the advice being provided is it's the incremental effect of a number of changes. You know, a number of things are being increased. It's slightly bigger, it's slightly higher, it's got dormers instead of roof windows. The incremental and cumulative effect of all these minor changes result in the development on which we are now recommending refusal on the grounds that it breaches council policy in terms of design, overdevelopment and amenity. So therefore the recommendation is to refuse for the reasons stated. At the previous meeting, members asked for clarification on points that were raised in paragraphs 423 and 424 of the committee report at that time in terms of the issue of car parking and land ownership. Following the last committee, therefore, first of all, I sought advice from the council roads officer and the council roads officer has indicated that they would object to the proposal if there were no car parking available. I'll just briefly read the conclusion of those comments. Traffic on the U101W is light, however, it is the only access route to this remote village. The inn is located at the entrance to the village and adjacent to the junction with the B7065. There are no recorded road traffic crashes at the location within the last 10 years. The car park at the other end of the village is over 300 metres away. Although it is not judged to be a high-risk location, the public road provides the only link into the village. Should no parking be available at this location, it is judged that the shortfall could not be catered for on the public road without significant impact on access to the village and the free flow of traffic. Under these circumstances, DG First would object to the development for the reasons given. So that would be the advice if it turned out that there was no dedicated off-street parking available for the hotel. So we then have to turn to the issue of the land ownership and the question of that land being leased back to the applicant or developer to provide that car parking. At the previous meeting, the applicant referred to an email he had received from CKD Gilbraith on behalf of the owners of Logan Estates that indicated that the lease would be re-granted to him. I therefore have contacted the agent in this regard, and I've had a personal telephone conversation with Mr. Roberts, the owner of Logan Estates. The email that was sent to the applicant to which he referred previously indicated that they saw no reason why the lease could not be re-granted over the car parking area opposite the Port Logan Inn should planning consent be obtained. I sought clarification from Mr. Roberts as to what was meant by should planning consent be obtained. What he said was, should all planning issues be resolved effectively? Because there are actually a number of additional issues in terms of the car park itself, which I didn't make reference to in the previous report because at that stage it wasn't material to the design and overdevelopment considerations there. The car park itself has also been the subject of challenge and enforcement action in terms of unauthorised developments. There was planning permission for a small car park was granted there in 2006 to the previous owner of the hotel, car park and some movable seating, picnic table type seating. The car park as built now is radically different from that approved. On being advised that that was the case, at the time the original application was made for the hotel extension we're now considering, an application was made in 2012 to regularise that development of the car park. Some of the elements that were involved at that time were fixed seating, not movable seating, concrete bases, light columns that members will have noted when they were on site, engineering operations in terms of changing levels and forming an embankment down to the beach. A septic tank was indicated, a toilet block was indicated. So there were a number of matters that were to be addressed under that planning application. However, that planning application was subsequently withdrawn in the face of a request from the planning authority for some substantial additional information in terms of land use, a site plan, questions about the bus shelter and telephone kiosk, questions about the purpose of the toilet block, doubt about the boundaries, issues with the embankment to the beach, clarification on the septic tank, clarification on surface water and drainage, and a request for specification of lighting. So these matters still remain to be resolved. So in order for Logan Estates to be satisfied that they could lease that land for the car park, and indeed an area of land to the north which was under a separate lease and was to be used for a construction compound, all of these matters would have to be resolved. Now, the main reason why we've left these matters to one side at the moment is we wanted to focus on the main issue, which was the hotel itself. So therefore, we served an enforcement notice regarding the breaches of planning control in the hotel. In terms of the breaches of planning control in the car park, we delayed that, firstly, as I say, because we wanted to focus on the main issue, which was the hotel, But secondly, because, first of all, if we were to serve enforcement notices, we would have to serve them on Logan Estates as landowner, as well as on the developer. And having liaised with Logan Estates, I was aware of the fact that their leases had a reinstatement condition in their lease anyway, so there was a mechanism whereby they could resolve the matters themselves. So that's where matters stand at the moment, and I apologise if I've gone on too long, but to try and summarise briefly, yes, the land for the car park could potentially be leased back to the owner of the hotel to provide the car parking. That therefore would take away any question of the roads officer objecting on those grounds. But that lease back would only be done if all of these matters were resolved. So planning permission granted for the hotel, all the breaches on the car park resolved, and or planning permission granted for changes. The one other point to make in conclusion is that, assuming either that planning permission were to be granted for the hotel, or as we would prefer, that it reverted to the original approval from 2011 and that car parking had to be provided, which is indeed a condition of that 2011 permission. The question would then arise as to how that was best managed in terms of land that was not in the ultimate ownership or control of the applicant. In other words, it was land that was leased from another owner. So we would need to look at the question of whether a condition was appropriate, or whether indeed we might have to look at the possibility of a legal agreement between the council, the landowner and the developer. I have again written to the landowner's agent asking what his thoughts would be on the question of potentially a legal agreement, but unfortunately I'm still awaiting a response on that point.
Thank you, Billy. Members, Councillor Brothers.
Thanks, Chairman. I think it's one of the questions I brought up last time, the car park and how that relates directly to the functioning and the extension of capacity was actually, I think my question was about, it would increase the capacity of the actual hotel itself. But I think what Billy's saying there is you're actually going to step further back, and it's put confusion, certainly set confusion for myself in regards to the previous permission. You would imagine that was granted subject to that parking facility being in perpetuity, but that's something I'm not just clear about. And if it wasn't in perpetuity, how would that affect us as a planning authority and conditions and such? Like, I'm a wee bit confused with that, Billy. I don't know if you can elaborate on that, and how do we move on with this procedurally, just for where we are, Chair.
Do you want to try and address that, Billy, if you don't mind?
Yes, the previous approval showed car parking in that area, and there is a condition on the planning permission for the previous approval that requires the car parking to be provided. The land was leased at that time. I would have to say that perhaps the planning authority was to some extent slightly at fault at that stage, that they didn't seek the detail of how long that lease would be or what the ultimate control would be. But the bottom line is that there is a condition requiring that car parking to be provided. I don't think there's much doubt that Logan Estates would have been happy to continue providing that car parking long term, and that therefore it should not have been a problem. However, in the unlikely event that the car parking ceased to become available, the developer would be the person who was ultimately responsible for compliance with that condition of planning permission. So it would fall to the developer to find a means of resolving that.
When you said if it was in 20 years' time, 20-year lease, and it fell at that point, it would be the owner applicant, or the owner at that point it would fall to. I take it they would inherit any conditions through the purchase.
Happy with that, Ian? Okay, Councillor Geddes and then Councillor McKee.
I take it, sir, we're now in session and in debate.
Yes, we are indeed.
Thanks very much, Chair. As far as I'm concerned, so the matter's in comparatively short compass. We are dealing with a particular application here before us today. It's recommended, in fact, that be refused, and I have no difficulties whatsoever, albeit I say with a matter of some regret, in supporting that recommendation. I mean, I appreciate that tourism is important, and the western part of Dumfries and Galloway probably important in the whole of Dumfries and Galloway. It's particularly important in the South Rins, but at the end of the day, sir, as far as I'm concerned, these proposals are such that, in my view, and that, to be fair, the importance of tourism to the local economy is recognised in the report by the author of the report, and I would commend them for that. But it would seem to me, sir, that the circumstances are such that, in my view, I feel that the only reasonable course for this council applying authority to adopt is to accept the recommendations in the report and refuse the application. And as I say, with a certain amount of regret, albeit, I will move that accordingly. Thank you.
Thank you for that, Councillor Geddes. Councillor McKee, then Councillor McCaughtry.
Thanks, Chair. I've got concerns about this lease as well. The foul sewage all runs into there, and they're talking about a new private package plant. Now, if that goes in there as well, and the lease is not renewed, and the hotel owner may be required to remove that, to return the site to its previous condition, that is with no sewage content there at all. And that would raise major concerns. And really, I don't think I would fully support what Councillor Geddes has said, and quite happy to second him. There's too many concerns there, I think.
Thanks for that, Councillor McKee. So we have a proposal to refuse via the officer's recommendation and a seconder. We've now got Councillor McCaughtry and then Councillor Ted Thompson, Councillor Maitland and Councillor Macomb in that order, please.
I was quite happy to go along with the recommendation. I think it's pretty clear. I think the site visit was worthwhile because you don't really get an idea of the scale of the thing by looking at the photographs, but certainly going there and seeing it on site, there is no way. I think the planners were very, very generous when they granted permission the first time, and I really think the developer is trying it on, quite frankly, and he should go on with the job that he was given permission for, because this is just a step too far. He's just taking the mickey.
Councillor Thompson.
Thank you, Chair. Again, I would actually concur with the remarks made by Councillor Geddes. I'd also concur with the remarks made by Councillor McCaughtry that the original application was extremely generous in trying to promote tourism in that area. I think what is in front of us today is actually very, very clear-cut, and that we should actually refuse on the grounds of the recommendations contained in the report.
Thanks, Councillor Thompson. Councillor Maitland.
Thank you. I'm glad we seem to be advancing down the line and rather all agreeing. Frankly, if there was any way in which I could rescind the previous application, I'd be in there trying to do that. Unfortunately, I don't think I can do it. But believe you me, if I had any opportunity, I would be doing that. I think what was done by the planners, actually, we need to send a clear message that what was done originally was quite outrageous with respect to that particular building line and the design and development of that whole village. That's a most attractive little village. And the line of the buildings was completely ruined by the original application. So with those remarks, I'll bring myself back to what I'm dealing with here and absolutely agree with the rest of the elected members' views.
Thank you, Councillor McCauley. Councillor Macomb.
Thanks, Chair. I accept the fact that we do want to be seen to be supporting tourism. But having visited the site and looked at the size of the footprint, looked at the design, the scale, the massing, there is no way I could support this proposal.
Thanks for that. Councillor Vice Chair.
Thanks, Chair. It's a matter of great regret where there's a development that supports the local economy and tourism, but quite frankly, given the recommendations, I would struggle, if I was so minded, to try and find a reason to move otherwise. And I appreciate that the planner has gone to some considerable degree to recognise the impact on the local economy and tourism. And I, for one, would certainly like nothing better to see an active, vibrant hotel in that location. But regrettably, I think there are no words that I could find that could do anything other than support the recommendations.
Thanks, Councillor Dick. Councillor Crothers and then Councillor Nicholl.
Thanks very much, Chair. I mean, I think I concur with Councillor Dick on that. We should always be seen to be promoting tourism, especially in the likes of that area where there isn't really much else in that side of Dumfries and Galloway. But under the circumstances, particularly for myself, the bit I'll focus on, I mean, look at the footprint, there's no a massive difference in the footprint, but I think Billy's outlined that's what's above ground, and that would be substantially different with it between dormers and roof lights and such like. We haven't really seen went into that in depth, but the thing that stops me digging any further is the fact that the car park and it's unresolved. It's still unresolved, and until such time as that was resolved, I've really struggled to support this application as it stands at the moment. So, for those reasons, I would support the recommendation contained within the report.
Thanks for that, Councillor Crothers. Councillor Nicholl.
Thank you, Chair. Yeah, I mean, we all want to support tourism, and this is a very busy village in the summertime, and there are a lot of people go sea angling and sailing and what have you from that beach. But this is out of proportion, and the applicant has run amok with the previous application, and some of it's out of character, and I have no difficulty whatsoever in agreeing with recommendations in the report.
Thanks for that, Councillor Nicholl. Everybody had their say. Can we have this as a unanimous decision by the committee that this is refused? Paula, would you like to just reiterate what's been said, please?
The committee is determined to refuse the application on the reports as set out, as on the grounds as set out in the reports. Apologies.
Thank you. We come to item 5 on the agenda, erection of dwelling house at Blackwoodridge, Eaglesfield, Lockerbie. Case Officer Lindsay Brown. Lindsay, when you're ready, just do your presentation, please.
Okay, if you'd like to take a look at the location plan in your committee papers, I'll take you through the photographs. Blackwoodridge is located approximately midway between Waterbeck and Eaglesfield, and this photograph has been taken from the B722 as you approach the site from Waterbeck to the north. The contractor's yard can be seen in the middle of the photograph, behind the row of bushes. You can just see the office porter cabin together with the roof of the large shed and one of the buildings remaining from the use of the site as a quarry. Access to the site is taken from the B722 opposite Blackwoodridge Cottage, which is towards the right hand side of the photograph. Moving closer to the site, this is a view of the western part of the yard with the application site itself located to the north of the access in the area behind the telegraph pole, which can be seen in the photograph. Moving into the site entrance, this photo looks towards the recently sited office porter cabin and security fencing, both of which are unauthorised. Again from the site entrance, this photo looks in a southeasterly direction across the contractor's yard and shows the general nature of existing development. Moving back to the edge of the B722, this photo looks towards the application site, which is located to the north of the yard access. The area is currently hard standing, which slopes gently down from the public road. While this photograph is a few years old, it shows the general nature of the application site and its relationship to its surroundings. Since this photo was taken, the entrance gates and fencing to the right-hand side of the photograph have been replaced with palisade gates and fencing, as could be seen in the previous photograph, and the timber larch lap panels have been removed and replaced by temporary Harris fencing adjoining the access. This final photograph has been taken from the B722 looking north. Again, whilst a few years old, it shows the relationship of the yard to both Blackwoodridge Cottage in the foreground and Blackwoodridge House in the middle ground. This is simply a location plan showing the relationship of the application site to both the yard and the existing dwellings. Whilst this isn't a great slide, it is the proposed site plan and shows the relationship of the proposed dwelling house to the road, the site entrance and the contractor's yard. And finally, this slide shows the elevations and floor plans for the proposed dwelling, which measures approximately 13.1 metres long by 7.62 metres wide and has a ridge height of 6.4 metres. The finishes include natural stone with a white paint finish, a natural slate roof and white UPVC windows. The application was deferred at the last meeting of the Planning Applications Committee following a request by the applicant to address alleged inaccuracies in the report. Subsequent to that committee and in accordance with the instruction, officers wrote to the applicant and a response was received. However, the response didn't raise any factual inaccuracies, but instead was a response to the committee report itself, and as such is a late representation and couldn't be taken into account in consideration of the application. Notwithstanding this, officers have reviewed the content of the letter and are content that there are no matters which would alter the recommendation or content of the report, and therefore the report which was in the October committee papers remains unchanged.
Thank you, Lindsay. And I know we did make a decision last month that we would determine this today. Do members have any questions on this matter for Lindsay? Councillor Blake.
Yeah, just one quick one. You referred to photographs that are old. Why are we actually presenting old photographs and not up-to-date ones?
Having reviewed the photographs that I had, I didn't have ones of those particular views, but because there was no particular change, it wasn't felt that the use of the older photographs was of any particular issue.
Thanks, Councillor Blake. I think maybe the only thing I would add would maybe be that, given that you did make reference to the fact there was Harris fencing replaced and a lap fence, that maybe it would have been useful to have more current photographs showing the exact nature of that particular change, but that's by the by. Councillor Dickon and Councillor Geddes.
Just a quick one, just to confirm. In 4.8 there you mentioned the fact that the site frontage and office porta cabin has been cited there, well, potentially acceptable. Both are unauthorised. I take it that has no bearing on the particular application in front of us.
Sorry, could you just repeat that?
Yeah, in 4.8 where you mentioned the fact that the porta cabin and fencing is unauthorised at the current site there. Am I right in saying that that has no bearing on the particular application in front of us at the moment?
Sorry, they're not for consideration under this application, but it is a matter of fact and therefore included in the report.
Councillor Geddes.
Thanks, Chair. I have a process issue that I would like to raise once this application before us has been determined today. Can I seek your leave to do so at the appropriate time? That's the issue of, as it were, referring, case officers referring applications to this committee for consideration. As I say, I think it goes much wider and much more beyond this application, so I would like, once we get this determined, sir, to raise the issue with colleagues and you, if that's acceptable to you.
That's okay. Are you happy to do it immediately, or would you like to do it as
no,
at the end
I would
of
want
the...
to leave that. I don't want to do anything which blurs the focus of considering this application, sir. I would like to do it once we've determined the application today, one way or another. There is a wider issue here that I feel we should be giving consideration to.
No, happy with that, Councillor
Thank
Geddes.
you.
What I was asking you was, after the thing has been determined, do you want to discuss that, or should you make it an item of agenda, item 19, at the end of the meeting? It's up to you, whichever you prefer.
I would prefer to do it, at the conclusion, but I'll be guided by yourself and your...
At the conclusion of the determination of this particular
Yes,
application?
aye.
Okay, that's fine.
Thank you.
Okay, that's fine. I have no problem with that, Councillor Geddes. Do any other members have anything they wish to add or ask? No? In that case, we have a recommendation to refuse. Is anyone otherwise minded? If not, in that case, the application is refused unanimously. Again, Paula, can you just reiterate what we've decided, please?
Committee is determined to refuse the application on the grounds set out in the report.
Thanks, Paula. Can we have Councillor Carruthers back, and then we'll ask Councillor Geddes to address the point he wishes to make. Councillor Carruthers, the item has been determined, but Councillor Geddes wants to raise a point on process in relation to process not necessarily this particular application.
Thanks very much, Chair. You know, my submission will be brief indeed. I would like a report brought before this committee explaining the rationale and the background, as it were, to the process whereby, in certain circumstances, planning officers are, entitled or have the right to bring applications to this committee for determination. I appreciate that there is a parallel right on the part of elected members to call applications in, and indeed I'm in the process of doing that at the moment myself. But I think that I personally would welcome some background and some further information on the rationale as to why we have this facility available. I'm not always sure that it's necessarily a well-founded arrangement. So I'm merely flagging up concerns that I have today, sir, asking you, if you're agreeable, to look at giving further consideration to this. And the way, of course, to do that would be to produce a report on the general aspect of it, for a future meeting of the committee. That's all I'm asking. Thank you.
Happy to concede that. I think I'll ask David to respond in a minute. I think the issue is that officers have the authority or right to bring to members anything they deem as an appropriate mechanism to be determined. But David, perhaps without a lengthy response, because we will get a report back, if you could just... Go on, Councillor McKean, I'll get David to respond to them all.
Sorry, I didn't have my mic on there. It's regarding this unauthorised work. Are we using enforcement action positive in the right way? There's so many sites we seem to go to where there's a lot of unauthorised work done, and the building's half built and they've no permission, they're coming for permission now and all this sort of thing. And I feel that the planning system is being abused. And just would like to hear your views just on what we could do about it, if anything.
I think in 4.4 and item 4 that we've already determined, the planning officer quite rightly advises us that any unauthorised work, we still treat that simply as a planning application that's brought before us, and we don't seek to punish anybody for doing that. And we carry out enforcement as and when it's been brought to our attention and when it's in the council's and the public interest to do so. And there are different levels of enforcement. And maybe again, David, if there's a document that explains how enforcement works and what the process is, if you could share that with members electronically, that would be fine. But I think that's where we are. But you can touch on that, David, but deal specifically with Alistair's question, please.
I'm very sorry to interrupt members, but apparently the volume is not all it could be. Could I ask members to speak a little bit closer to the microphone as clearly as possible, because the members of the public are struggling to hear you.
Okay, I'll speak clearly into the microphone then, hopefully that'll work. There's two issues, two questions there. The enforcement one is probably the easier one to deal with. There is a very useful document which I would commend to all members, and indeed I'll undertake at the end of the meeting to circulate it round to all of you. It is on our website. It's our enforcement charter, and that explains how the enforcement system works. It is not a criminally prosecutable offence to actually undertake works that are development that need planning permission without a grant of planning permission. It only becomes a criminal offence where we have served an enforcement notice and that notice is not complied with. So there's a due process that has to be gone through. It's also clear that you can't use the enforcement system as a punitive measure. You can't use it to punish people for actually having jumped the gun. Many people will have done this throughout without realising that they were breaching planning control and it was a genuine mistake. Other people maybe less so. But really with that process, we have to invite an application in the first place, and I think Lindsay will correct me, but I'm fairly certain that's been done with this one here for the porta cabin and the fence. It has been disputed, shall we say, by the applicant, but nonetheless it has been requested. It then falls to the planning authority to determine if nothing is submitted, is it in the public interest to actually proceed to serve an enforcement notice and go. Some things inevitably, had an application been submitted, would have been granted. They will remain unauthorised. They're carried out entirely at the own risk of the applicant. but you can't use the planning system as a punitive measure. As I say. What I will do is I'll circulate around the enforcement charter to all of you, which has only just been updated, I think, about April this year, so it's a very up-to-date document. And it is a very useful background for all of you to understand the system in which we have to work, because it is quite bureaucratic. It does take time to resolve a lot of issues, but there are due processes that I'm afraid we do have to follow, because in the event of an appeal, if we've not followed due process, then it can very often fall. In respect of the issue, I don't know how much to say. If the committee are wanting to agree to Councillor Geddes' request that a report come forward, then I don't know how much I want to actually say at this stage, but I can give you a very straightforward answer. If you don't want to actually have a formal report, the scheme of delegation is unambiguous in this regard. It very clearly states that notwithstanding the terms of when applications must be referred to the planning applications under the scheme of delegation, it is entirely at officers' discretion as to which applications can also be put forward. The first paragraph of every report explains why it's come before you, and we will make it clear if it is something that officers feel it is something which members should make a decision on rather than officers. And there could be any number of reasons for that. In this particular application's case, it is because it has a long history of actually having been before Area Committee, and there was a clear steer given by the Area Committee in one particular direction before, which unfortunately wasn't taken up. But nonetheless, that's the reason why we felt this one, because of its history and previous Area Committee involvement, should be a Planning Applications Committee decision. It's not something we do. The vast majority of applications, some 93% of applications, are dealt with under delegated powers and don't come before yourselves. But there will be the one or two cases which do need to come before yourselves, which we think it's politically expedient to do so, or there's some historical reason why we feel, if members have made a decision on a particular proposal before, it might be beneficial for members to do that.
Councillor Geddes, do you want to come back?
Yes, it's just in relation to the use of, by Mr Sutty of the words entirely at the discretion. Now, it seems to me that phraseology, Chairman, does not, in my opinion, lie particularly comfortably, as it were, with a scheme of delegation. But I'm not intending to get into, an argument, for want of a better term, or an exchange of views with Mr Sutty today. What I'm saying is that I personally feel that this is an issue that, would benefit from being brought before elected members to ensure, in fact, that we are quite clear as to just exactly what the bones of the current arrangement provide, why, in fact, that that situation has been arrived at, and whether or not, in fact, going back to that particular phraseology, that is acceptable, because I have certain reservations, speaking personally. If in fact, at the end of the day, it's felt that it would not be necessary to have a report, well, I personally will ask for a briefing note on the matter, because there are issues here which I personally feel, in fact, are worthy of further consideration and a certain degree of clarification, Chairman. Thank you.
Happy with that, Alistair. And I have two members wanting to speak, Archer and Tom, but I wouldn't want this to develop into a full-scale debate today. I think we're here on to deal with planning matters. And if David's happy to provide a briefing note and that satisfies what members want, that'll be fine. So, you happy with that, Archie? Tom? Happy with that? Okay. In that case, thanks very much, members. Sorry, folks, for the deviation from the agenda. We're now in item 6. Formation of new access to Garroch Farm, enlargement of A75 Garroch roundabout, realignment of Glen Road, and ancillary works at the Garroch roundabout, A75 the Glen, Dumfries. Case officer is Patrick Hanna, and we have 4 people looking to speak. Do we get in the Pat first? Pat, you do the presentation first, please.
Thanks, Chair. First of all, could I update members of correction to the report? At section 3 of the report, the number of objections should read 13 and not 12. And below David Fallis, I'd ask you to add, again, David Fallis of 8A Rochelle Park, Dumfries, on behalf of Mr. J. O'Hagan instead of Mr. M. O'Hagan above. A little bit of background on this application. As members will recall, planning permission was granted in April this year for planning permission in principle for the relocation of the Dumfries and Galloway Royal Infirmary to the Garroch site. That planning permission in principle does not allow a partial implementation of a development, and therefore the current full application has been submitted to allow the construction of the roundabout in itself to be brought forward. And this will allow the NHS to hand over a serviced site to the successful contract bidder. Construction on the project, on the roadworks, is intended to commence in spring-summer 2014, with completion by end of 2014. And the new hospital is currently timetabled to begin construction in spring-summer 2015, with completion by late 2017-2018. This is an indicative layout for the planning permission in principle, and you can see that at the top right-hand corner of the screen, there's the Garroch roundabout, from which is to be realigned with a new arm coming off to the south and the realignment of the Glen Road. Again, an aerial view showing the roadworks to the right-hand side of the screen. And this was a photo montage that was provided at the time of a view from the Garroch roundabout. The current application site relates to the area in red only. And this is the existing arrangement on the site. The road on the top right-hand side of the screen is the A75 heading into Dumfries. On the top left-hand side of the screen is the A75 heading to Stranraer, where it just rises up the hill and then over to Lockfoot. On the lower right-hand side of the screen is the Garroch loaning, and the lower left-hand side is the existing Glen Road. The proposal is to have a new arm coming off the roundabout to the south, with the Glen Road realigned to join that arm. You can see on this particular image that the proposed roadworks are in black and the existing road layout is shown in grey. So you can see that the roundabout is to be enlarged slightly, twisted around slightly, some minor amendments to displays coming into the roundabout, and then the new arm coming off it. One thing that is worth pointing out is that all of the roads shown are due to be adopted roads, and the hospital access actually starts to the south of the road network that you see there. A landscaping plan has been submitted showing some minor verge works to the immature woodlands around the roundabout, and some wildflower bunds around the new arm. This is a photograph on the approach along the A75 heading east towards the roundabout, and you can see the Garroch building in the background. The western approach towards the roundabout, with the site just beyond. Garroch loaning approach, with the site to the left-hand side. This is moving forward and looking at the roundabout itself, with the new arm to come off directly to the left, and sort of stepping sideways, if you like, looking at the field itself with the new arm to come in, and the new arm will extend in this image to somewhere approximately between the two trees. And on the Glen Road itself, the realignment will occur approximately beyond the road sign that you can see on the left-hand side. Objections have been raised from the Community Council and 13 third parties, and these relate primarily to, firstly, road design, secondly, traffic management, and thirdly, impact upon local businesses. In terms of design, objectors have suggested that 5 arms for the roundabout should be retained, i.e. the retention of the Glen Road and a new access solely for the hospital. However, that's not what is proposed, it's not what's before us, and would represent a fundamentally different proposal, and would require a new application. Furthermore, and critically, Transport Scotland have indicated that they would object to a new roundabout with 5 arms on it. In terms of traffic management, there's no doubt that residents and businesses in the immediate locality are likely to suffer some disruption during construction. It's inevitable within any roadworks that some disruption will occur. However, a traffic management plan is proposed and required by condition, and that would include measures to minimise disruption, details of temporary signage, and the methods of notification of the works to members of the public. Finally, in terms of impacts upon local businesses during construction, that would be managed by the traffic management plan, and in the longer term, it should be recognised that the relocation of the hospital would offer benefits and potentially opportunities for local businesses in the area. For the reasons set out in the report, the proposal is considered to be acceptable and is recommended for approval. Thank you.
Thank you, Pat. Any members have any questions? Tom, Doctor.
Just, but Pat mentioned that Transport Scotland would object to a five-legged roundabout. But can you just make it quite clear? Transport Scotland can object all they want. It's this committee that makes the decision. They've got no special. They've got no more. It could be somebody staying along the street saying, "I object to a five-legged roundabout." So they've got no more clout than any other objector. I think that should be made clear. Is that correct?
That is indeed correct, yes.
Thanks for that, Councillor McCarthy. Anyone else have any questions for Pat? Patsy?
Just on that, why are they objecting?
They're not objecting to the current proposal because...
why would they object to a five-legged?
The reasons that they would object are set out in paragraph 4.4, and that states that they have evidence indicating that the number of accidents per year increases with the number of arms on a roundabout because of the corresponding increases in the number of potential conflict points. They have also indicated that when it becomes a larger roundabout, which is needed for additional arms, that drivers tend to drive around it much faster, which makes it much more difficult to get out and is more likely to result in accidents. And potentially an example of that is the Glasgow Road roundabout that I'm sure everyone in this room will be familiar with, that has very fast traffic movements around it and can be disconcerting at times. So Transport Scotland have indicated that they will not support 5 arms on a roundabout. And it should be borne in mind as well that the applicant has been in extensive discussions with Transport Scotland throughout this whole process and have taken their advice in formulating the current application. Whilst it's up to the applicant to submit whatever design they choose, and it's up to members of this committee to determine as they see fit, the NHS have taken the advice of Transport Scotland into account.
Thanks, I'm happy, Pat. Yeah. So quite happy. Councillor Geddes.
Thanks, Chair. So to be absolutely clear, in relation to trunk roads, etc., Transport Scotland are regarded, for want of a better term, as the road safety authority, whereas for the all other roads, such as A, B, Cs, etc., it would be the Chief Constable of Police Scotland. Is that correct?
I think the police would be consulted, but it would be a roads officer in general terms as well that would make recommendations. But on the trunk road, the 75, 76, 77, it's Transport Scotland that are the perceived experts.
Yeah, but the point I'm making, though, Chair, is that, in other words, do they stand in the stead of, in relation to road safety matters, do they stand in the stead of the Chief Constable? That's really my specific question, just in the back of what Tom said earlier.
I'm sure Pat or David will answer that. I would think it'd be a joint thing. The Chief Constable invited to comment, but their statutory roads authority. Pat?
In terms of enforcement, I can't answer that question, I'm afraid, and I don't know whether David knows whether it's Transport Scotland or the Chief Constable that is responsible for enforcement. In terms of road design, it's Transport Scotland that are responsible for advising on that.
Thanks, Alistair. Stephen?
Thank you, Chair. It was just a quick question about off-road cycle provision, and I was just wondering where that featured in the current design for the roundabout.
It is certainly cycle provision is included within the proposal. If I run back through the images, you can see that there is already some. Not on this one, sorry. There's a cycle path along the Garroch loaning already on the approach to the roundabout. And going back to the drawings, it's not very clear from the drawings, but it is shown on there that there is a cycle path that will continue around along the new access on the right-hand side of that access, and then you can see that it crosses over the road and allows cyclists to either continue up the Glen Road or into the hospital site itself. Cycle provision has been integral to the whole of this process throughout, right from the original application.
Happy with that, Stephen. Councillor Maitland.
Could I just... I'm so sorry. Sorry.
I omitted to allow Councillor Carruthers in, but I'm sure he's a gentleman. I'm sure I'll let you carry on if you want, Jane, and I'll get Councillor Carruthers next.
I'm so sorry. What I was just wanting to know is, because I seem to remember that the blue light vehicles, emergency vehicles, there was some sort of difference of access. Can I be absolutely clear where the blue light vehicles will be coming?
To be quite frank, there's no absolute clarity on that at this point in time. The planning permission in principle application included a layout, and that indicated that blue light traffic would come onto the new arm and then turn right to go down the Glen Road and come in at the northwest corner of the site, and then immediately to the A&E department, which is sited just below the helipad that you can see there. However, that is only an indicative layout at this point in time, and until a successful bidder has been appointed by the NHS who will design the final detail of the layout, there's no certainty as to exactly where the blue light access will be taken. But certainly as an indicative proposal, it was intended to try and segregate blue light from regular traffic through the hospital site itself as part of an overall transport strategy that also included the third service access to keep service vehicles away from blue light traffic and from general traffic to the hospital.
I think Councillor Maitland wants to come back, but I think as well we should be absolutely sure that this is an application to formalise reconstruction of this road as part of the process, of the ongoing process of development of the hospital site. Councillor Maitland, you want to come back in?
Well, it's just, I just wonder, struggling really about this with respect to our locus in this. I mean, is it possible for us to say, hang on a second, is that, you know, is if we agree this, is there going to be some possible level of conflict between things turning right, blue light vehicles muddled up with people going to the farm and up to the Glen, to the farm shop and up to the Glen? I mean, I'm just looking at this. I sort of slightly say, hang on a second. Is this should we actually be agreeing this? I mean, I accept that, you know, this is a planning application and advised by safety agencies, but I'm just slightly concerned about this, actually, Chairman.
Okay, David has just whispered to me that might be a question you'd wish to pose to the applicant when they make representation here today.
Thank you for your advice.
Councillor Carruthers, sorry about not letting you in earlier, and then Councillor McComb.
Absolutely fine, Chairman. I've lost that track myself many occasions in regards to keeping on track with people and whatnot. See, when it goes back to statutory consultees, we've got a clear example in Dumfries and Galloway, particularly Andy Alnestale, where the MOD, the Observatory, have objected to a certain radius within it. So, sorry, I'll get a wee bit closer, Jock, so that you can hear me. In Andy on Estill, we have a standing objection against wind farms, wind turbines in any way, shape or form within a certain radius of the observatory because of seismology. Now, if a statutory objector, now every application is turned in right to first instance when it comes to that. So if Transport Scotland are saying, listen, if it was a 5-armed roundabout, we'd object to this. The council can still determine in the 5-armed that they could approve it, but if it come back in the form of a report, what would the report look like from an officers if it was a delegate decision? I'm just trying to get a clear understanding because statutory, it's just what role it's been touched on earlier. What role does a statutory objection take when it comes to consideration? What would the response be? How would the Scottish Government look at that as well?
I think it may be that the applicant might appeal their decision, but we decide at the end of the day, and I think we offer or present a weighting factor to whatever objections might be brought to this committee by whatever statutory organisation. And as has been outlined by Pat, they've given reasons, Transport Scotland, why they wouldn't want to see a 5-arm roundabout in this location, and it would be for us to make that determination whether or not if that was presented. But the fact of the matter is, we're being presented with an application here, and this is what we have to determine today. But I appreciate what you're saying, but Pat might want to expand on that.
I was just going to say that if, in the event that a different application was submitted to us that Transport Scotland did object to, and if in the event that members were reminded to approve that application, then it would be subject to referral to Scottish ministers, because Transport Scotland are a statutory consultee. But we're getting into lots of ifs there.
Thanks, Pat. But the usual caveat exists, members. We are where we are. We have an application before us, and that's what we have to determine today. If there are no other members wishing to speak, the first representation... Oh, sorry, Jim. I do apologise. I had your name down as well.
Thanks, Chair. Could I ask Pat to go back to the outline plan for the roundabout? That one, yes. Now, you'll notice in that plan that it states access to Garroch Farm to be maintained at all times. Surely, a similar statement should be in that plan with regard to the Glen Road. Yep. You've got Kilnford Barns there with over 170,000 people visiting it. You've got a number of premises on the Glen Road as well. I think it is essential that these people their access be maintained.
I don't have any particular comment to make in response to that, other than the fact that a traffic management plan is required that will need to outline exactly how the construction process will be undertaken. And if you just bear with me for one moment.
While Pat's looking for that, it might be another question for the applicant or his agent, how they would maintain access to the Glen, but if Pat can help, that'll be fine. Apparently it's in condition 2 in any case, Councillor McComb, so we can let...
Right, okay, the applicant, apologies for the delay there, just checking that the applicant has submitted a brief summary of what the traffic management plan would relate to, and in that it does say that it's not envisaged that complete closure of the roundabout will be required at any stage. It has to be borne in mind that it says it's not envisaged, and a traffic management plan needs to look at the construction process in exact and precise detail, and the NHS may be able to enlighten you further on that, but it may well be that because we're just at the planning application stage, that they may not yet be at the stage of precisely working out how the construction of the development would occur.
Thanks, Councillor McComb. Anyone else? Any questions for Pat at this time? Okay, then we have 3 objectors, or maybe Mr. Fallis first. And I wonder if you might first advise whether you know you're representing 2 individuals or 1, please.
I'm representing 2 individuals, Value Mark Furnishings and Mr. John O'Hagan. But they're not mutually exclusive. We can combine both at the same time if it pleases the committee. I'll just deal with it at the one time and sort of compress things if you're agreeable to that.
That would be great. Thanks, Mr. Fallis.
Okay,
You have the
thank
usual
you.
3 minutes.
Have to confess to having a wee touch of deja vu here from the application earlier on in the year with regards to my clients' concerns. Fundamentally, the concerns that they have relate to significant disruptions that are going to be caused to them through the use of their domestic property and indeed their business through works that are going to be required at their access onto the Garroch loaning. Just for point of clarification, it's the access onto Garroch loaning coming from the south. So there's both the domestic property and the business, and it accommodates something like 100 vehicle movements on a daily basis, both domestic cars, but also delivery vehicles, rigid bodied delivery vehicles, some with trailers. So the nature of vehicles going in and out is just not just a domestic car. The concerns have not been, these previous concerns have not been alleviated by the content within the application, because the fundamentals that they have against this are all tied up with this traffic management plan that is to be provided by a yet to be identified third party who is not, part of the process here, and whether they will be fully aware of all the concerns and considerations that my client have, as well as other parties up the Glen, in preparing their traffic management to facilitate their construction of their roundabout, is a matter for, it would appear, consideration at a later date. Again, the concern that my clients have is that the traffic management plan will be prepared. It's not as if it's open for debate to third parties or anything like that. It's purely probably at the discretion of the contractors whether or not they'll engage with the locals. Chances are it'll be a case of, we're going to be blocking your access up for 3 weeks. That starts on Friday, so try and make the most amends of it. With regards to my clients' concerns, it is possible to mitigate their concerns in one fell swoop, and that is, as previously suggested, to bring about the earlier introduction of what is going to be the service access of the Garroch Industrial Estate at the south of my client's premises, which backs onto, just 2 or 3, you can see it there. If we've got the roundabout, at the top of the picture, and their access as we described, you come right down south to it, you can see where my client's premises are. It'd be an easy enough action just to provide that access of the existing adopted road through the estate, and then facilitate a rite of passage for my client to actually utilise that, so that all traffic, even for the domestic property, could still go through that part, so it would obviate the need for any disruption of their premises themselves. The other part relates...
3 minutes up, Mr. Fallis.
Well, if we had the two of them, then, it's just a wee indulgence, if you wouldn't mind, thank you. The other matter relates to the landscaping. It's identified that the bunding would be a maximum of 3 metres. Whilst it does cause the client concern if it is restricted to an absolute of 3 metres, preferably less, then that is something they could countenance. But again, with all the site works that are likely to be done, a great fear they have is that a huge bund of soil will be put along the communal boundary and will obliterate their amenity for the duration of the contract. There's nothing in any of the drawings to say that that would not be the case, or that such soil bunds would be found elsewhere, and it's maybe a matter that the council could oblige us with in ensuring that their long-term amenity is protected throughout the construction works as well as the long-term use of the site. Thank you for your time considerations this morning. I'll ask any questions you wish.
Thank you, Mr. Fallis. Do any members have any question for Mr. Fallis? Thank you. Oh, you have, Councillor Carruthers.
Thanks, yeah. If you could just go over, you said it 30 seconds, I just missed it. You said 30 seconds left. Just remind me again, because I'm not that afraid with what's there. I think I picked up the generalisation of it, but you spoke about the road that links through. I think I've got a grasp of it. You want that to be opened up first, or kept open, because there could be restrictive access. Just if we could get that explained again, please.
Yeah, I think a part of you got your wee red dot there. where you've got the large circle, which the new building's in the centre of, at roughly maybe about 4 o'clock on the clock face, there's a white building behind some identified trees. That's the my Value Mark's current premises there. Now, you've got the yard to the back of that, and then there is a little access being shown just to the north of that other belt of landscaping trees. That's intended to be the service access that comes off the Garroch Industrial Estate. It's not presently there, but provision is made in principal application for that to form the service route.
Thanks very much. Just for clarification, what's being asked is that that road is made available before that other road is stopped up or blocked in any way, I think. Is that what's being asked you? So I'm sure.
Yeah, that's being suggested. To actually provide that in, the grand scheme of things of the project here is a very simple, straightforward operation and work, and, it's unlikely to be challenged on the basis of, a simple road opening permit and the provision of a right of access across what would be the Health Trust's land, or whoever it is that designs and builds the thing.
Thanks for that, Councillor Colour. Does anybody else have any questions? Thank you very much, Mr. Fallis. We now have Mr. John Rome, please. Again, you have 3 minutes, Mr. Rome, and there's a little button on the front of the console you can press and your red light will come on. Whenever you're ready, sir.
Thank you very much, ladies and gentlemen, for giving me the opportunity to speak and to convey my concerns about your proposals for the roundabout. As introduced, I'm the owner of Garroch Farm Shop and Restaurant. First of all, I've read the guidance notes, and I do understand that I'm not allowed to speak about commercial concerns. The thrust of my application is centred on the last bullet point, which is in the guidance notes, which is the degree to which an unacceptable proposal can be made acceptable by imposing conditions. I would ask the committee to be aware that our new business, which has received government funding to assist it with the infrastructure, it's only 2.5 years old. It now employs 40 staff from a standing start, and it's been a real asset to Dumfries and Galloway. The most important part in planning the whole process at Kilmford Barns as a farm shop was the visibility and easy access from the A75. We realised that it would be essential to have good signage in the form of the brown tourist signs, which most people recognise. Unfortunately, due to the complexities of dealing with 4 agencies, it took us 4 years to complete that process. And in spite of an enormous effort on our part, it was spring 2013 before we opened. This had a huge detrimental effect on the establishment of our business. Now, I make this point to stress that our business is very vulnerable to any disruption of access, as customers will simply choose to go elsewhere. Now, I accept that the hospital will have a positive effect on the survival of the business after 2018. But if this transition is not handled carefully, we may not survive till then, and all that's been created for Dumfries and Galloway will be lost. The sensible way forward is for a 5-leg roundabout. There's ample land available, no link road would be required, so probably no extra cost incurred. The Glasgow Road roundabout, in spite of what has been said, with 6 legs, carries a similar volume of traffic, perfectly satisfactory. If the well-designed 5-leg roundabout with an increase in diameter would be safe if it was well-designed and satisfy the needs of the users, I would ask you to be aware that all of the traffic build-up on the A75 round Dumfries at the moment is on the 4-leg roundabout at Lockerbie Road, not on the 6-leg roundabout. So there's no reason why the 5-leg roundabout should not be successful.
You have 30 seconds to go, sir.
Whatever format's agreed, I would hope that the Contractors carrying out this be legally required by the conditions of the planning to maintain a good quality access at all time. And they should be required to consult with the Glen residents and businesses to provide us with proposed layouts, timescales in advance to ensure minimum disruption. I would stress that we have good relations with the hospital team, and I would hope that will continue, but I would ask the committee to put conditions in place so that our survival is protected by extending a binding condition rather than relying on goodwill, which could become stretched as cost and time pressures begin to bite. It's absolutely vital to the survival of Glen Barns.
Thank you for your presentation. Does anybody have any questions for Mr. Rowan? In that case, thank you very much, Mr. Rowan. Just take your seat again, please. We now have Stephen Howie and Ken Asher, applicant and agent. And I presume, gentlemen, you're doing the 3 minutes jointly. Thank you.
Good morning, I'm Stephen Howie, NHS Design Manager for the project. The detailed plans for the new hospital are progressing quickly, and we're aiming to be on site to start construction in April 2015. And we're aiming to keep to that date because of the size of the project and the effect building inflation will have on our budget. So the purpose of this application being submitted now is to ensure that we have suitable access to the site ready for the contractor in early 2015. It's necessary to have the road alteration carried out in advance of the hospital to ensure that there's as little disruption to traffic on the A75 and the local network as possible. The hospital will be a massive construction project with 500 people on site at any one time, and we must ensure that we can get them onto site as efficiently as possible so that they don't cause a delay to the local and trunk road traffic. Permission today will help us deliver that alteration by the start of 2015. We understand the level of local concern this application has raised. We've engaged with the individuals and groups to understand their concerns, and as a responsible neighbour, we've challenged our designers over these concerns. The NHS have no preference over what kind of access is created to this site. We want the best, most free-flowing, safest road access to serve the people of Dumfries and Galloway accessing their District General Hospital. We've set up a neighbour liaison group which have been very useful to hear everyone's concerns. These concerns have been discussed with the statutory authorities to ensure consideration has been given to all points that they've raised that are causing them concerns. And we've come back, they've all come back with this design as being the safest, most appropriate, free-flowing junction that we can create for this piece of major infrastructure that we're all looking forward to. We intend to continue this liaison group throughout the construction of the hospital, and this will give everyone the opportunity to raise their concerns directly with the project group. We will also ensure that the road contractor who's appointed will appoint a liaison manager who will link directly on a day-to-day basis with the neighbour groups and discuss with them what's happening on a daily basis so that they're aware of what disruption there's going to be. If that's required to be a legal requirement, as has been requested, we're quite happy with that to be the case.
Ken Asher from Asher Associates. We were the designers of putting together the preliminary design for the roundabout Glen Road. And really, I'm not going to add anything else because there's not a lot of time left. Appreciate that, but I'm here mainly to answer questions rather that you may have on the technical aspects of the scheme.
Thank you, Mr. Asher. Mr. Howie, that's excellent. Gentlemen, do you have any questions I've got? Councillor Dryburgh, then Councillor McKee.
Thanks, Chair. Patrick, I wonder if you can go back to the proposed layout of the roundabout. Yeah, that one there. I don't know, Mr Asher, perhaps you're the one to ask this question. When you look at that realignment of Glen Road there, there would be a tie-in to the old Glen Road. I'm presuming that the Glen Road would stay open until the new tie-in was actually in place. Would that be part of the process of building that roundabout?
Yeah, the traffic management plan that was referred to earlier, it is a sort of twofold thing in this case, because I think traffic management plans are becoming the norm for all large developments now, in terms of how traffic gets to and from the sites and how it operates in terms of the locale around the site. But in this case, clearly it's the traffic management of the roundabout works and how the works are carried out is quite crucial. To see, if you like, a kind of flip chart of how to get from A to Z, to get the finished works completed while minimising disruption to all the users on the roundabout. And that is what was referred to earlier, and there's been quite a lot of discussion about, that the intention is that when Transport Scotland appoint their contractor, the first thing their contractor will need to do is provide a detailed traffic management plan and look at how he will minimise the disruption to all road users, not just the Glen. Obviously there's a major consideration in terms of the trunk road itself and Garroch loaning and access to all legs. So he will be producing that. I would imagine, without putting words in his mouth, that the initial major bit of work will be to do the offline work. So in other words, everything that is in the existing field to the south of the Glen Road and the roundabout would be built first. And as you said, there would be a tie-in to Glen Road, which would only be made at the same time as the tie-in to the roundabout itself. The main A75 roundabout is made.
Okay, thank you.
Thanks, Councillor Driver. Councillor McKee.
Hi, Chair. Part of my question has been answered. It was the width of the road from the roundabout into the site, but also are you comfortable with the width of the realigned Glen Road, given we've been talking about blue light access and what have you? Are you comfortable that you've got enough width there if there's traffic on that road for the blue light to overtake?
I don't think it's really my place to comment on the blue light side of things, because that I think I'll be corrected if I'm wrong here, but it's not part of this application. We're really looking for consent for the works to the roundabout, and the issue of whether the blue light traffic uses Glen Road or doesn't use Glen Road and how it works will be subject to the detailed work that's still to come in the hospital site proper.
Happy with that, Councillor McKee. Councillor Maitland and then Councillor Crawley.
Thank you, yes, but surely you actually have to build that in at this point, the blue light issue, because if I've got this in my mind, if the blue light traffic came off the roundabout and went onto the road as it is now and up along the back, then you would have a direct and straight access off the roundabout, as opposed to turning right, I think, which is the option. And so, I mean, I struggle to understand why it's not important to think about that now. Maybe I could be given some help.
Yeah, sorry, I may be misleading you slightly there. We did think about it, yes. We have worked that in, but all I'm saying is that the blue light, where the blue light access is taken, is specifically part of the overall design of the hospital and how that all works. But as far as the design was concerned, our key issue in the design was to ensure that right turning traffic coming in off the roundabout, the road is widened to 3 lanes, so there's a right turn lane to enable traffic coming off the bypass to turn right onto Glen Road and to have an island to sit in terms of everyday traffic. The point has been raised by Glen Road, particularly GTR Contracting, who are based up Glen Road, that they've got low loaders, take big excavators in and out. We've looked at that in more detail in terms of swept paths, because the key thing in terms of the blue light use would be to ensure that if there is an Arctic coming out of Glen Road at the same time as an ambulance is coming in, that there would be no clash in terms of how that works, that the ambulance wouldn't be held up by having to wait for an Arctic to manoeuvre around. So we've done quite a bit of work on that. We opened up the radius on the bypass side of the Glen Road junction specifically for that reason. Further, more detailed work is ongoing at the minute in terms of the finalisation of the detailed design. And it looks like the Glen Road Bellmouth will be opened up still further to ensure that the amount of space available for turning movements is more than ample.
Again, Jane.
Thank you very much. That's very helpful. Thank you for that. My next question is more an aesthetics question. At the moment, the road off to the farm shop is actually rather a sort of nice, rural, small little road. And this is going to be really not. It's going to be filled with lights and toucan crossings, or possibly not, as the case may be, I notice. Has anybody considered that? Did anybody consider that in the process, or are we just looking at getting low loaders and ambulances in and out?
No, we've tried to consider all aspects, obviously, but there was a landscaping drawing which Pat put up on the screen earlier on, and maybe that is the best way of answering the question, because on the landscaping drawing there's hedging shown on either side of Glen Road. That's new hedging to be put in, which would serve to help to redefine the new line of Glen Road, to blank off the bit of Glen Road that will become redundant nearest the roundabout, because clearly it's important that's grubbed up and removed completely so there's no confusion to road users. So there's hedging shown to either side. There was also been some discussion about street lighting, which I think is particularly pertinent in that. On the scheme as submitted, I think we have shown no street lighting on Glen Road itself, but that's still subject to the detailed design aspects. And it's a local road, therefore it's the council's as road authority to decide on what they want on that side of things.
Happy with that, Councillor? Councillor Crothers?
Thanks, Chairman. I suppose I'll take on board what you said earlier in regards to we're looking at this, the roundabout itself today, because a couple of my questions were kind of going a wee bit adrift for that. Taking that into consideration, we've got Glasgow Road roundabout. I know it's much larger, maybe that's the reason why it hasn't been implemented here, but it's if we imposed Glasgow Road, the construction design there, or the layout anyways, it would probably fit and satisfy the concerns that are being raised, because you'd have that extra leg that would come off and you have that direct link. I mean, that's the main question is why can we not actually do that? Why can we not fulfil, is it just down to size or whatever it is? Just
The point's been made earlier on, and it's clear in the report that Transport Scotland, it's sort of 4 legs good, 5 legs bad, to sort of change the Orwellianism slightly. But the Glasgow Road situation was an existing situation, and it was a best fit to that existing situation to put in a 6-leg roundabout. There already were all these other roads there, and they had to be accommodated when the bypass was built. And it's what's called a diversion from standard, if you like, in order to make that acceptable. So in that case, it was an existing situation in terms of the number of roads that were there, and it was the best solution in terms of that particular circumstance. Here we've got an existing 4-leg roundabout. We're talking about introducing a new situation, and in introducing that new situation, Transport Scotland are then applying what they would apply to a new situation and saying, no, it needs to be 4 legs. If I can just digress slightly, when the hospital sites were being examined, the strongest alternative site was at Lockerbie Road, coming in off Lockerbie Road roundabout and onto the Summerfield farmland. And there it would have been easier to take a direct link off the bypass roundabout in the same way as here, but Transport Scotland would not allow that because they wouldn't allow that roundabout to be made into a 5-leg roundabout and Lockerbie Road still to be accommodated. So in that situation, Lockerbie Road was to be used and then the hospital was to come off Lockerbie Road on a new junction. It was one reason why this site was preferred to the other site, was it was simpler to take access off the bypass directly in this location.
Can I come back to you quick on that? I take that on board what's been said there.
Carry on.
Just in reference to, will anybody's access be stopped up whilst this is under construction?
Clearly the intention is to minimise disruption in terms of building it to everybody, as I said earlier on. And the point was made fairly earlier that we've got a note in the drawing saying that the access up the Garroch Farm road is not to be closed at any time. It would be valid to say the same sort of comment on the Glen Road junction. The only thing with doing that is that you've got practicalities of what happens when you're completing the works in terms of the final top coat even going on the road. That sometimes there just needs to be a temporary closure if it's even for a couple of hours in order to enable that to happen. But the clear intent is to keep traffic moving at all times.
Thanks, Councillor Carson. I think it's obvious to members, though, what has been said before, we are here to determine an application today. We're not debating or discussing how we might get into a five-leg situation on this roundabout. To do that, it need to be a refusal of the application today and the applicant to bring forward an alternative proposal. Councillor Nicholl.
Thank you, Chair. Four-leg roundabout, if that's what's to be, that's what's in front of us. We have to decide now. But my concerns are on the Glen Road junction from the new road into the hospital. And I have serious concerns about the amount of traffic that will be going in and out of the hospital in the shape of visitors and staff, etc., etc. And also the traffic going up the Glen Road with residents, with the farm shop, restaurant, and also with the contracting company that's up there. If anybody's ever gone up the Castle Douglas Ayr Road, and as they approach Ayr, there's a hospital, fairly large hospital on the left-hand side of the road, and that, at certain times of the day, is absolute mayhem. Traffic queued right back from the Ayr bypass, right past the hospital. They've even had to put in a set of traffic lights there, which weren't there originally. And I have serious concerns about the amount of traffic that will be using this road, which will be similar to the amount of traffic that's using the Ayr Hospital situation. So I have great difficulty at this point, and I would like to ask Mr Asher if he's got a point that if they're convinced that this is the right junction to be having here, because you've got Arctics going in and out, etc., and I just have serious concerns about that. But Mr Asher maybe can give us reassurance.
Well, I think that's been said a few times already today, and it's part of the report anyway. But gentlemen, can you just quickly respond to that?
There was a statement put in with the planning application as a non-technical summary of transportation assessment and traffic issues, which was referring to the work that was carried out by MVA, who carried out the transportation assessment work for the relocation of the hospital. And there was a huge amount of detailed work carried out as part of that to look at the flows that would be generated by the new hospital, relocated really by the new hospital in terms of shifting it across town. And this design was developed out of that. It was developed between ourselves and MVA and is now being finalised by Transport Scotland's consultant to ensure that the flows are catered for.
Councillor McComb.
Thanks, Chair. My question has already been asked by Councillor Nicholl. I do have serious concerns about the volume of traffic on the Glen Road, particularly the proposal to have the blue light traffic on a road carrying 175,000 visitors, plus the residential and local business traffic.
Okay, we'll deal with that when we're in session. Councillor Maitland, Councillor Groom, and then Councillor Driver.
It was just a matter of simply fact, and to ask Mr Asher if I could. There are three, I thought there are three lighting columns, 25 feet lighting columns going up the Glen Road, according to these drawings here that on the website. And I would just like to know whether they are absolutely essential or whether they're not, because frankly, if they're not essential in terms of regulations and all the rest of it, I don't think they should be there. I think actually it leads to confusion, and that road up there is a rural road leading, one hopes, to a community, and I think it should stay like that. So if we could ask the technical question about how necessary they are.
That'll be fine, I'm sure they'll answer that.
The detail of that will be covered by the road construction consent application, which will be lodged shortly to the council. As I said earlier, in terms of my personal view, I would agree with you, but it's something that will be reviewed in terms of the road safety aspects through the RCC process.
Councillor Groom.
Mine's is just to voice the same concerns as Councillor McComb about the 170,000 visitors that we get up that road. And we're going to have all this extra traffic and blue light traffic.
I'm sure we'll deal with that when we're in session. Councillor Driver.
Thanks, Chair. Maybe a question to both Mr Howie and Mr Asher. You mentioned about the importance of keeping the locals involved in this moving forward, and you said you had sort of communication groups and that set up. I just wonder how often that actually meets and how often you will do that during the construction phase if this application is granted.
Since meeting with the individuals over the whole period when we've been developing the planning application for the hospital, we decided that a better way to coordinate this was to pull together a liaison group, and that liaison group has met 3 times since the outline permission was given. It would be our intention to continue that right through the construction phase of the total development. I can't say just how frequently it would need to be. We'd need to assess that. The intention would be as whenever there was information to be passed to our neighbours about changing work practices from when it be clearing the site to going to piling to starting to bring tower cranes on or whatever, we would be wanting to convey this information. Whether it was convening that liaison group or just putting a newsletter out, it would be in discussion with the group as to how they felt best we could convey the information to them. For the roundabout contract, we would be ensuring it was written into the contract for whoever the contractor is successful for building this, that they have someone available on site every day that is contactable by any of the neighbours. The project team will also be contactable on a daily basis by neighbours so that any concerns or issues can be dealt with immediately.
Okay, any other questions, members? In that case, thank you very much, gentlemen. We're now in session. Councillor McCaughey.
Thanks, Chairman. I think we've had a fairly good go at this. Obviously, over the wee while as one of the local members, I've had quite a few people bending my ear about this. I would say that the applicant seems to have placed a lot more weight on what's been said by Transport Scotland, who are just a statutory objector, than they have to the local businesses, many of which are long established, and to the local residents. Now, that is entirely their affair, why they want to give more credence to a statutory body than they do to the folk who are actually going to be most affected by it. So with that in mind, I would be moved to refuse this application at this time and perhaps give guidance to the applicant as to what might be more applicable for the future. And I would refuse it on the grounds that it's detrimental to the proper traffic management in that area. It's detrimental to the amenity of the Garroch farmhouse, vis-a-vis the 3-metre bunds they intend to erect. And it's got a detrimental, an adverse effect on the businesses operating in that area. I think that for Transport Scotland to say they object to having more than 4 legs, they haven't produced any evidence to back that up. They've made some glib statement that there's more accidents, the traffic moves faster. I see no evidence before us as a committee here, so unless they present evidence, then I can't accept it. And it was Transport Scotland themselves who approved, or their predecessor, I should say, who approved the 6-legged roundabout just 3/4 mile up the road at Glasgow Street. And I think, as other members have said, there's 5-legged roundabouts elsewhere. So I see nothing wrong if we refuse this one and guide them, come back with a 5-legged roundabout, and also to assuage some of the other concerns, and that is the service road be opened up at this stage at the top of the plan as outlined. There's a couple other issues that I had. I mean, Councillor Maitland's quite correct in the first instance. When the outline plan came to us, the Glen Road, the new Glen Road, was highlighted as the access for blue light traffic, and you can see that in the original outline submission. There's a road at the top end to access into the accident and emergency area. Now, at the end of the day, if they're wanting ambulances to move quicker, a 5-legged roundabout would be a far better option, because ambulances come straight off the roundabout, a 5-legged roundabout, and up the Glen Road, instead of having to come off on a 4-legged roundabout and have a dog leg to get access to the Glen Road. So they're actually defeating their own purpose in trying to have a first-class accident emergency service by putting a dog leg in there, it would inhibit the flow of ambulances that were in a hurry. But I think for the reasons I've outlined, this should be refused, guidance given to the applicant, put a bit more weight on the wishes of the local people and the needs of the local businesses, have a five-legged roundabout and open up your business, open up the service access at the top of the road. And I would so move, Chair.
Okay, we'll have Councillor Dick looking in, then we'll see whether I know that's an appropriate phraseology to use for reasons for refusal. Councillor Dick.
Well, I think on the basis of this application that's before us today, it makes absolute sense to have an access from somewhere in the roundabout. Seems to me to be sensible. What I am concerned about, and I would take advice as to whether it's subject to a further application, a further consideration down the line, is what has been expressed by a number of members in here about the levels of traffic. We only have to look at the amount of traffic that goes up to our existing hospital and the one that Councillor Nicholl had cited up between Ayr and Castle Douglas. There's a phenomenal amount of traffic there. We're also trying to service a highly successful business there. I appreciate, and it's not a planning consideration, but a hospital on your doorstep with construction people before are bound to hopefully enhance those businesses, but it doesn't get away from the fact there's a massive amount of traffic to be dealt with. For the purposes of this application, I have no problem in moving approval. I do think some consideration need to be given because I'm some concern about the plans I've seen there and the numbers of access into these sites. The site of existing business, local residents and a massive hospital, and I think that has to be given some serious consideration, possibly some other access. But I think because on the basis of this particular application, they certainly need a way in, and it makes sense to approve it.
Councillor Dryburgh.
Thanks, Chair. I'm tending to agree with Councillor Dick on this one, but I would add perhaps one other thing to the conditions, which is to make sure that there's access to the old Glen Road at all times until the tie-in actually happens. With that, if Ian was happy with that, to add that particular condition, then I'd be happy to go along with that.
Yes, I would.
If that is a proposal, and if we can tie that into a condition that it's not already in existence, that would be fine. Firstly, can we establish whether Councillor McCaffrey has a supporter for his proposal to refuse this application? Councillor Blake.
I've given this matter a lot of consideration. I do appreciate that the hospital needs an entrance, but I think it's too big a price to pay for the users of that particular road. It's shown, or we have details that it's got a fairly heavy traffic. It may very well, and it probably will affect the business there. And I think another solution has to be found. Where I would probably hate to see traffic lights on the A75 and the A713 outside there, that is the case, and it does assist entrance into the hospital. And a five-leg junction may be feasible with traffic lights. I think we have to look at some other way of servicing this.
Okay, so on that basis, are you supporting Councillor?
Sorry, I am supporting.
Fine, then. Well, before Councillor Dick comes in, can we establish whether or not Councillor McCaffrey's grounds for refusal are acceptable in policy terms, and can we ensure that a condition is placed to keep the old Glen Road open at all times if it's not already in the document?
Taking the second one first, Chair, I would suggest condition 2 could actually just have an extra line put at the end of it to address your concern, basically saying the traffic management plan that should be submitted shall ensure that the Glen Road, the existing Glen Road, shall remain open for as much time as practicable. I think we've heard from Mr. Asher that there might be a matter of even a few hours where they just have to close that. So I don't think you could have a condition that said it must remain open at all times. But as far as practicable, I think that would be a competent condition. In respect of the other one, Paula, could you read back what you've actually got for the reason for refusal, please?
Refused on the basis of the detrimental impact on the proper traffic management of the area, the detrimental impact on the amenity of the Garroch farmhouse, and the adverse effect on businesses in the area. Is that? Yes.
Is that competent?
The second bit, I'm not sure about the Garroch farmhouse, because we've got on the plans that it's to remain open at all times. I think that's shown on the plan, isn't it, Pat?
No, it was the funding at Garroch farmhouse.
Yeah. Oh, right, sorry. I mean, these are road safety and amenity concerns, which are material planning considerations. So, yeah, it's. Sorry, what do you think there? And the economic aspect. Yeah, can we have that very last bit again, please?
The third reason I have noticed is the detrimental or adverse effect on the businesses in the area.
Again, that would probably need clarification, because are you saying during construction or as part of the overall development? Because we have to look at the planning authority at the overall development that you're seeing here. It is always accepted that there will be some disruption during construction, as Pat pointed out earlier. But would this development that you're seeing on the screen there, would that actually affect the businesses? If you're refusing it on those grounds, I would say that's a dubious ground for refusal, I'm afraid.
I mean, two grounds there anyway. That I'm happy with the 2 grounds. You can drop that one. Yeah.
Thanks, Councillor McGoffrey. Councillor Dick.
Yeah, it's just to ask advice on the point that a number of us have raised about the levels of our concerns about the levels of traffic and what could be done in the future, whether it could be a further recommendation in here or an issue. It's a procedural issue. How do you take this up with the health authority and consider the grounds which may result in a further access?
The bit I'm kind of struggling with is the planning permission in principle has been granted for a hospital on this site, which it was implicit that you were going to get that level of traffic. So the council's accepted the principle of that level of traffic going in here off the Garroch roundabout. And it seems a little late to be querying that. The issues about the specific layout that you've got before you now is something which is obviously competent for you to consider. But the level of traffic, I don't think it's open to the planning authority, given that there's a planning permission in principle being granted to look at that again.
Okay, last thing before we go to the vote. I'm happy to accept that the old Glen Road can remain, a condition be placed that it remain open as long as practicable. But I wouldn't like a situation to evolve where it was closed for 5 days and that was practicable. You know, there must be somehow we can ensure that on any given day that road is open for a specified period of time. I've now got 4 members. I've got Councillor Councillor Maitland, Councillor McKee, Councillor Crothers, and did you want back in, Councillor? Right. McKee, Crothers, Maitland, McKee, and then Crothers.
Thank you very much indeed, Chairman. I just want to clarify a couple of things which I raised earlier, which was that our roads officer, the council's roads officer, has suggested that there should not be a toucan crossing on proposed Arm C. Now, if we're agreeing to Asher Associates drawing number AA3978/G, etc., in condition 1, are we therefore agreeing to a toucan crossing? Can we be clear about that? That's question 1. And question 2 is about the lights on the realigned Glen Road that I mentioned, the 3 lights, which I would also like to suggest that we don't have, if we don't absolutely have to have them for the purposes of road safety. And then if the movers and seconders would be happy to put that in, that would...
it would be subject to advice from roads officers and Councillor Maitland, because as far as I understand it, a new reconstruction requires lights that are specific length and therefore specific distance away from a roundabout, but that would be something we would determine from our professional staff, if you're happy to have that included, subject to appropriate advice being provided, and in both these elements, that would be fine. If that's what members are happy to, especially the mover and the seconder, are happy to include. Okay. Councillor McKee.
Thanks, Chair. It was just that if we accept this proposal here today, is that including the access into Garroch Business Park for the businesses up in Garroch Depot, so that the access off Garroch Loaning can be built and there's no disruption to those businesses?
David?
That's not actually part of this planning application, but clearly the relevant people are here from the NHS today to actually hear that, and I'm sure they can take that forward to look at that as early as possible. But it's not part of this planning application, so we couldn't reasonably condition that that take place.
The usual thing will apply, Councillor McKee, whereby we will indicate to the applicant and agents that we have concerns in relation to A, B and C, and hopefully they'll take that way and address them. But we are confined to dealing with what is before us at this present moment in time. Councillor Carruthers.
Thanks, Chair. Just when it came to the roads issue being potentially closed off for a period of time, I think that would have to be an application to the Roads Authority anyways, just clarification on that, even though it could be a condition.
There will obviously need to be a roads construction consent application, which will that will set out how it's all going to actually work as far as the local authority is concerned. The traffic management plan should be able to address the other issues. As far as the street lighting goes, that was concerned, I think we've also heard that that would have to be audited for safety, whether or not take it as read. If they don't have to be there, then they won't be, because I think everybody agrees that would be better if it's not there. And certainly we can pass that information on to our roads colleagues and ensure that where possible they don't have the lights there.
Okay, on that basis, are we ready to proceed to the vote? We have a recommendation to be approved by Councillor Dick, seconded by Councillor Dryborough. Recommendation refused by Councillor McCaughey, seconded by Councillor Blake. I'll ask Paula to read out the terms of both of these recommendations, please.
The motion proposed by Councillor Dick, seconded by Councillor Dryborough, is to approve, subject to amendment of condition 2, to add in the line, the traffic management plan shall ensure that the Glen Road shall remain open as much as practicable. The amendment proposed by Councillor McCaughey, seconded by Councillor Blake, is to refuse on the grounds of that the proposal be detrimental to the proper traffic management of the area and detrimental to the amenity of the Garroch Farm, specifically with regard to the bunding. Everybody okay? Chair.
Motion. Motion.
Councillor Dick.
Motion.
Councillor Blake.
Amendment.
Councillor Carruthers.
Motion.
Councillor Dryborough.
Motion.
Councillor Geddes. Councillor Gilroy. Councillor Groom. Councillor Maitland.
Motion.
Councillor McCaughey.
Amendment.
Councillor McComb.
Motion.
Councillor McKee.
Motion.
Councillor Nicholl.
Motion.
Councillor Stephen Thompson.
Motion.
Councillor Ted Thompson.
Motion.
Yeah, 11 votes for the motion, 4 votes for the amendment. The motion is carried. The committee has determined to approve the application subject to the amendment of condition 2.
Thanks for that, members. We go on to item 7. Variation of condition 2, limiting duration of permission to 4 years of planning permission P//170/228(07/P/30740 to retain wind monitoring mast for a further period of 2 years at White Hill, Auchencairn Forest. Again, Case Officers Pat Hanna. Pat, please.
Thank you, Chair. Okay, thanks, David. A little bit of background to this application. In 2007, an application for a mast in this location was refused by the then Area Committee on Environmental and Visual Impact grounds. A subsequent application in 2008 for the same development was also refused by the then Area Committee. That second application was then appealed to Scottish ministers, and Scottish ministers upheld the appeal and granted planning permission for a temporary period of 4 years. The mast was installed in September 2009, and that permission expired in September 2013. The current application seeks to retain the mast until September 2015. Since the installation of the mast, a planning application has been submitted for the erection of 16 wind turbines of 121 metres in height at Auchencairn Forest. That application has not yet been determined. The slide here shows the location of the mast, approximately 4 kilometres from A village over to the middle right-hand side of the screen, and approximately 5 kilometres from Aldgirth down to the bottom left-hand corner of the screen. This is a block plan. It's largely within a forested area, and I've put a red dot there on one of the forestry paths, which is where some photographs have been taken from at a distance of 1.2 kilometres from the existing mast. But you'll note from this that there's no public roads in the close vicinity. This is an elevation of the mast itself. This is a photograph taken of the existing mast from 1.2 kilometres. It is central on the screen there. It's very, very difficult to make out, and so I've highlighted the height and location of it in red there. So the tip of the arrow is the tip of the mast. Zooming in closer, as much as I could with the camera, you can again just see the mast there. In terms of visual amenity, the photographs indicate that the mast has a minimal impact, and justification for the extended period of time has been provided by the applicant, and that's contained within the report, and that's considered reasonable, particularly in light of the minimal visual impact of the proposal. A key consideration of this application, however, is the undetermined planning application for the wind farm at Auchencairn, which includes 2 permanent masts. It's anticipated that that application will be determined in any event, even if it was to go to appeal, within that 2-year period. Finally, in line with recent practice, a condition is attached requiring the installation of an infrared light on top of the mast, where it's currently a visible red light on top of the mast. However, the application is recommended for approval.
Thanks, Pat. Any members have any questions of the case officer? Councillor Driver.
Thanks, Chair. My understanding of these masts is to get as much information as possible over a short period of time to ensure that they can place a future application, perhaps for a wind farm. And this has been up for 4 years. We have recently, of course, said to people who are bringing forward applications that we would reduce it to 2 years rather than the 3 years that was originally on the recommendations. I'm not quite sure why they give the reasons that they're given. They're bound to have the information because it's been up for 4 years.
Okay, thanks, Chair. Well, within the report, I've summarised the justification that's been provided by the applicant, and they've stated firstly that in effect that the longer period of time you have, the better quantitative results you get. Secondly, they refer to potential reduction in the number of wind turbines in the concurrent application for the wind farm, and that may result in a need to reevaluate the wind resources. And finally, they've referred to the fact that the adjacent Dowswinton wind farm has indicated high wind shear, meaning that they may have to take some remote sensing measurements of wind at the site. And remote sensing measurements are effectively a laser that's placed on the ground, and the light is shone up into the sky, and that measures wind. But in order to calibrate that, it has to be calibrated against an existing mast. That's the justification that's been put forward by the applicant, and it's considered to be reasonable in light of the visual impact of the proposal and in light of the existing application, concurrent application for the wind farm, which would include 2 permanent met masts. That said, it's acknowledged in the report that members have regularly reduced the time frame for such masts, and it's entirely within your remit to do that, if you consider there's justification to do that.
Councillor Blake.
Thank you. I appreciate we're not here to determine the wind farm application, but I think you alluded to the fact there were 2 masts within that application. Is this mast on the location of one of these? Because if it does, that's probably the reason it's asked for an extension, because it will not be taken down.
I'm afraid I can't answer that question. I would need to refer to the separate wind farm application to identify precisely where that is. I mean, it's possible that I could come back to that later, but I don't have that information with me to hand.
I wouldn't have thought it necessary to determine this application, because we are here for this application very specifically today, and that's what we have to determine. But if Councillor Blake wants that information, I'm sure you can ensure that he gets it later part, although that has no influence at all, no bearing on any decision we might make today. Any other member for the case officer? In that case, we have one objector, Penelope Coles, on behalf of Closeburn Community Council. Penelope, you have 3 minutes again. Thank you.
Closeburn Community Council are unable to represent themselves today owing to work commitments, but they have asked me to pass on some comments to councillors, basically that they're still very unhappy with this met mast. Their objection is fully documented in the committee report, but they'd like to draw your attention to the following points. That the reporter who originally approved this application acknowledged that there would be visual impacts on the key receptors of Closeburn, Thornhill and Keir Mill, because the mast is in a highly visible location, and it's been in place longer than recent met mast permissions of 2 or 3 year duration. Now, since the representations have been made, a further supporting statement has been issued. It really should have come as no surprise that a site 2 kilometres north-northeast of Dalswinton Wind Farm would suffer turbulence. We're delighted to hear that they're actually planning to reduce the number of turbines, and many local residents will hope that it'll make the proposal financially unviable. Because the wind speed of the site is marginal. If you look at the wind energy diagram in Technical Paper 5, still a current document of the Council, it's an area with low wind speeds, not much above 6 metres per second. Dalswinton struggles, varies between 20 to 23% capacity, when it should be running at 30%. We were interested to hear the news yesterday from the Scottish Government that Dalswinton, the only Dumfries and Galloway wind farm, has been selected for inclusion into a 14-month study on the effects of visual intrusion, noise and shadow flicker because of the close proximity of the wind farm to residents' homes. So residents of Closeburn and Aldgirth will be keen to take part. Dalswinton, Blackwood and Auchencairn are not remote sites. This LIDAR or SODAR assessment at Auchencairn really should have been undertaken during the past 4 years, but we recognise that it will be difficult to refuse when a task has been identified. However, we welcome the news that the wind farm should be determined in the next 2 years, and we also thank the case officer for recommending infrared lighting in line with current practice by councillors. Thank you.
Thanks very much, Mrs. Coles. Anyone have any questions for Mrs. Coles? In that case, thank you very much, Mrs. Coles. Kindly return to your seat. Members are now in session. Councillor Crothers.
Thanks, Chairman. Just a quick one in regards to settlements being within a 2.5 kilometre radius of the actual application site. Is there any that you're aware of, considering what we've put forward in the new local development plan, Chair?
Pat?
Any settlements, did you say?
Sorry, Pat, just for, I mean, we agreed, I think it was settlements in particular, I don't think it was individual dwellings. I could be corrected on that, just to be sure. New local development plan, it's 2.5 kilometre exclusion zone, I think.
Okay. Well, on the plan here, you can see that the Met mast is shown as a yellow triangle, and the red dot is 1.2 kilometres away from that. To the left-hand side of the screen, you can see Auchencairn, which is a cluster of, or there are a cluster of properties within that area there. And moving out, there are individual and potentially clusters of properties within 2 kilometres, but settlements, no.
Councillor Dick.
Chair, I think given the reasons that the applicant has made in requesting this further period of time, my first impression was why, well, 6 years, I said, but I think quite clearly, if this is going to determine the future financial viability of any further developments of turbines, I'd find it very hard to refuse and fully accept that the condition I think we all want to see now, which is the infrared lights, has been accepted, and I would move approval.
Councillor McKee.
Fair enough what Councillor Dick's saying, but what has he been doing for 4 years? What difference in our 2 years got to make? The wind, unless there's been no wind for 4 years, and then all of a sudden he's got some information for the Met Office that's got to have wind for the next 2 years. That would be reasonable, but I think to have 4 years and still know he made a decision, you kind of wonder where the devil they're coming for at all.
I think there will be lots of members with that kind of question in mind. Councillor Geddes.
Thanks, Chair. I would second Councillor Dick's motion in these circumstances.
Councillor Dryborough.
Thanks very much, Chair. I mean, obviously there's been a mast here for 4 years and I've been picking up information from that particular mast. It is, as the objector says, been an eyesore to some of the people up there, and it has got a cumulative impact in the industrial cluster as far as the community council is concerned. So I'm minded to actually refuse this application because it should have had the information prior to this, but I would refuse it as contrary to General Policy 7. In the site and design, it's been there, it is an eyesore for people in that particular area. It's had the information, it should have equated that information and made applications come forward, but I'm sure, like in previous applications, the business case wasn't ready. However, I'm want to refuse this on General Policy 7, and it's contrary to that.
Okay, given that they are saying that they're using the additional data with a view to reducing the proposed number of sites in their application, that's fine. That's their justification for it. Stephen Thompson.
Just a clarification on if the intention is to gather data on the basis that a subsequent application would have fewer turbines, does that mean that length of time for gathering the data needs to be expected? Is it the minimum of 12 months of actual data over a 2-year period? So would that push back any potential application, or is it going to draw on the data that's already been gathered and add that on to the new data which is listed in the 4.4 there, considering the reduction in the number of turbines? So this amendment would take account of that, or I'm sort of struggling to see the consistency in the argument there.
I think without tying any case officer down to specific dates and times, I think Pat said quite clearly that the application would be before us before a 2-year period had elapsed, and that would be part of the information that was used to present to us for that application. But Pat might want to just clarify that for us.
Certainly, the wind farm application that we have for Auchencairn has been with us since 2011, and I would certainly hope that that can be drawn to a conclusion within the relatively near future. Assessing wind farm applications is always complicated, and there may be reasons for delay, but at this point in time I don't see any reason why that separate concurrent application shouldn't be determined within that 2-year period.
And
Certainly
we're not here
sooner.
today again to deviate from what's happening within this application. The applications for the mast only, whether or no the one farm application determined will be a matter of due course and due process, and it's nothing to do with anything that might be said today in relation to that, Councillor McKee. Good. Okay, so currently we have a proposal from Councillor Dick, seconded by Councillor Geddes, to approve the application. We have a proposal from Councillor Dryborough to refuse it on GP7, and Councillor McKee has seconded that.
Sorry, Councillor Dryborough, can I just confirm I picked up your reason properly? You believe that the development is contrary to General Policy 7 siting and design. Is that due to its unacceptable visual impact? Thank you.
And are both proposals suggesting that we require the red light to be changed? Well, if it's a refusal, it'll be removed anyway, but we insist the red light be changed. Okay. Is that amendment competent to refuse, David?
I think if you're basically saying that you're refusing its retention for a further period on the grounds that its retention will continue to have an adverse visual impact, that's sort of grounds I'm quite comfortable with.
Can you just rehearse what the amendment and
the motion
is?
proposed by Councillor Dick, seconded by Councillor Geddes, is to approve the development subject to conditions as set out in the report. The amendment proposed by Councillor Dryborough, seconded by Councillor McKee, is to refuse the application on the grounds that the retention of the mast would have an unacceptable visual impact and therefore be contrary to General Policy 7 siting and design. Okay. Chair.
Motion.
Councillor Dick.
Motion.
Councillor Blake.
Amendment.
Councillor Carruthers.
Motion.
Councillor Dryborough.
Amendment.
Councillor Geddes. Councillor Gilroy. Councillor Groom.
Amendment.
Councillor Maitland.
Amendment.
Councillor McCotry. Not here, sorry. Councillor McComb.
Amendment.
Councillor McKee.
Amendment.
Not here. Councillor Nicholl.
Motion.
Councillor Stephen Thompson.
Amendment.
Councillor Ted Thompson.
Amendment.
You missed Patsy. I have amendment. 5-9. Yep, that's 5 votes for the motion, 9 votes for the amendment. The application is refused.
We'll have a 30-minute recess and then we'll resume again at 1:15. Replacement windows for a temporary period of 20 years. Late listed building consent at Now Farm, Kirkconnell, Sanker, and the case officer is Patrick Hanna. But before that, David Sutty has a bit of correspondence he might want to share with you.
Thank you, Chair. It's really just to inform you that we've received a letter from Mr. Mike Woodcock, who is, I think, the Director of Ingersoll Investments Limited, who are the applicants here. In summary, he's saying he's actually out of the country until 2nd of December and is requesting that the application be deferred to a future meeting to allow him to actually attend. I'm in your hands as to how you wish to deal with that, but I would direct you to the front of every set of agenda papers that you have. It's the inside page is request for continuation, sets out previously agreed guidelines which the Planning, Housing and Environment Services Committee had agreed. Circumstances where it should be, or such a request should be refused are A, where the reason for request is the inability of an applicant, objector, agent or other party to attend a particular meeting. Their attendance is not essential to the Council's consideration of the application and it can cause serious inconvenience to other parties who have taken the trouble to attend. So there is clear guidance on that, but I'm in your hands as to whether or not you wish to agree to his request for a deferral.
It's no caused any serious disruption to anybody else, but Councillor Drybrough?
Yeah, I was just going to say, sir, according to the bit of paper that we have for speaker, there's no registered speakers in this particular one. I don't know if there is one or that's coming late or whatever. If there isn't, and they've got no, considering what we did last month with a particular request from an applicant, I've got no problem in saying we defer this till the future meeting.
If members are in agreement, then what we should do, if that's you're arguing or presenting a case for consistency, the consistency was that we would tell the applicant it will be determined at the very next Planning Applications Committee meeting, which I think is scheduled for 11th of December, is it? Aye. So, if you are of a mind to defer, we should advise the applicant that it will be determined on the 11th of December. Councillor Maitland, then Councillor McCaughey.
Chairman, while I understand why people want to do that, actually that's two rights or two wrongs not making a right. And we've got a policy here, and I think it's bizarre not to follow it. We should have last time round, and so I would suggest that we deal with it today.
Okay, we've got Paula wanting to say something, then I've got Councillor McCaughey, Councillor Carruthers.
Just on a governance point to members, and members shouldn't bind themselves to determine something. To consider it is perfectly fine. You can't bind yourselves to determine it, because that means you're ruling out a site visit before you've even heard the article.
Can you just run that past us again, Paula?
I have absolutely no issue with the committee determining that they will consider something at their next meeting. What I don't want, and what I won't put in the minute, is that you will determine it at your next meeting, because you're then binding your hands at the next meeting should you wish to consider it for a valid reason, such as a site visit. You're preempting a future decision of the committee.
Okay, because we did that the last time. We tell the applicant to be
And it was
determined,
minuted that the committee would consider it at the next available meeting.
Councillor McCaughey and then Councillor Carruthers.
Thanks, Chair. Happy to second Councillor Drybrough. Well, when did the gentleman say he was going to be at the country toll?
2nd of December.
So that would be appropriate for our next meeting, which is the 11th.
Papers are already out for our next meeting, Chair. 11th of December.
Well, I don't think, what we can't do then is we can't have an open-ended situation. That wouldn't be fair, neither an applicant nor staff. We need to decide which committee this paper should be presented to.
There's no problem. It's already been in the public domain, so there's no problem sending out the papers again for the 11th of December. We've all had a copy of the papers. We're doing this basically to hear from the applicant. Was this not up before this particular application?
Not to my knowledge, no.
From some time in the past.
But anyway, you've got a proposal and a seconder from Councillor Drybrough, Councillor McCaughey. You've got a proposal from Councillor Maitland. You've now got Councillor Carruthers and then Councillor McComb.
Thanks, Chairman. Just in the aspects of people being able to speak, I would support McCaughey and Drybrough on this one. But will they have the right to speak? They're not included in this one. Does that mean they'll have it? That's for a matter of information for myself. It will not change the decision. I think we should be consistent. But will they have the right to represent and speak at the next committee, if they can make it?
Provided we don't start to determine the application, defer it right away, it will be a new application and it will start with representation or a presentation from the case officer followed by objectors and applicants in the usual manner. So that won't cause the applicant a problem. The problem we have is whether or no we're going to determine it today, and if we're no, then, or we're going to consider it today, should I say, and then if we know when we're going to consider it, because it shouldn't be left. You've got it here because officers can't find a solution to this. They don't think 20 years is really temporary and they want a resolution to it. That's fair and reasonable. Councillor McComb, then Councillor McKee.
Chairman, if I just come back, is it as long as the applicant then comes back, is it within 48 hours or have they already asked to speak? Because it's not in front of us today. Have they got up until, is it 48 hours or whatever it is? Before
no, the rules are different for applicants. The rules are different for community councils as well. It's only individual objectors that are limited to when they can notify the council they want to make a representation. That's right, isn't it, David?
He would have to, just to answer Councillor McKee's comment earlier, the LRB papers are ready and done, but the agenda papers for the Planning Applications Committee won't be finalised until Friday, I think, Tracy. Is that right? Friday it will be finalised? Yeah. So there is time for us to put this to the 11th of December, should you so wish. We would then have to write out and tell people, and they have to register 48 hours prior to actually speaking. 48 hours prior to the committee of their intention to speak. So that would be on 10:30 on Monday the 9th. They would have had to have let us know that they intended to speak. But just again to reiterate, this was a previous policy which was agreed. These are guidelines. Well, it's not policy; it's guidelines which were set out by the FES committee as to when we should and shouldn't be accepting this, because it was it's not been bad recently, but in the past it was quite regular occurrence where people were just saying, "Oh, I can't attend this meeting," and something would be deferred. Which in this particular application, it so happens that there's no other speakers, but if it becomes a common practice, then you could be affecting people who've come some distance, and then just because one party can't come along, then the whole thing's deferred, which has effects on performance as well as the members of the public.
I think we would consider every case in its merit in any case. That's normal, and it's guidelines. There's no binding on us, so it's really up to members to decide what to do. Councillor McComb.
Thanks, Chair. I'm prepared to second Councillor Maitland's amendment that it be considered today.
Okay, so I don't think that needs much clarification, Paula. We either consider it or we don't. Motion to consider it, motion to defer until the 11th of December, and amendment to consider it today. Is that right, Paula? Just clarify that, please.
Yes, the motion is to defer consideration to until your next meeting, which would be the 11th of December. The amendment is to consider this item today. Chair.
Amendment.
Councillor Dick isn't here. Councillor Blake.
Amendment.
Councillor Carruthers.
Amendment.
Councillor Dryborough.
Motion.
Councillor Geddes. Councillor Gilroy. Councillor Groom. Councillor Maitland.
Amendment.
Councillor McCotry.
Motion.
Councillor McComb.
Amendment.
Councillor McKee.
Motion.
Councillor Nicholl.
Amendment.
Councillor Stephen Thompson.
Amendment.
Councillor Ted Thompson. That's 5 votes for the motion, 9 votes for the amendment. The committee will proceed to consider this application today.
Okay, on that basis, Pat, do you take us through the presentation, please?
Thank you, Chair. A little bit of background to this application. In early 2011, Historic Scotland advised the Council of the unauthorised installation of the 22 UPVC windows in the now farm in Kirkconnell, and this is a Category B listed building. Shortly thereafter, an enforcement notice was served requiring reinstatement of timber sash and case windows within 3 months. A late listed building consent application was then submitted, which was subsequently refused under delegated powers. And then in 2012, a new enforcement notice was served allowing phasing of reinstatement of the windows over a period of 1 year. Since that time, negotiations have failed to reach any satisfactory conclusion, and instead the applicant has submitted the current application for the retention of the unauthorised windows for a period of 20 years. The application site is just to the west of Kirkconnell. The settlement boundary of Kirkconnell is just on the bottom right-hand side of the screen. The now farmhouse is identified within the red line boundary, and the principal elevation of the building faces east, southeast. This is a photographic record that we have from 1997, which shows the original 12-pane sash and case windows and the replacement windows. Again, looking at the original windows and the replacement windows. This is a photograph that the Conservation Officer has from 1999. And again, the replacement windows. And turning around onto the last elevation, you can see, and in detail, the casement windows that have been installed The original 12-pane sash and case windows contributed significantly to the special historic character of this listed building, and the replacements are considered to be unacceptable in terms of proportions, opening method. They have a top-hung opening window at the top, detailing and materials. And the proposal to retain the windows for a period of 20 years would be tantamount to a permanent approval, and during that time would fail to preserve the character and appearance of this listed building. And for the reasons set out in the report, the proposal is considered to be unacceptable and is therefore recommended for refusal. If the application is refused, then it would result in a new enforcement notice being served under delegated powers for reinstatement within a period of 1 year. Thanks, Chair.
Thanks, Pat. Any member, any questions for Pat? There are no recorded speakers, so we're in session. Members, Councillor McKee and Councillor Dryborough.
There's two things, Chair. On paragraph 4.6, there's in 1997 the council also provided a listed building grant, and the reference number there, to the owner of the premises, providing financial assistance towards the renewal and repair of traditional windows. Have you anything that proves that that money was used for that? And if not, where is that money now? And the other thing I was going to raise was the time it's taken, these late listed building consents and the notices to improve things and that sort of thing, is the amount of time it's taken, and you're extending the time scale all the time. Instead of enforcing, you're just extending and letting them get away with it. It's like this temporary period of 20 years. I was kind of worried about that, just how long's temporary. And they seem to be just dragging us along, I think.
I think Councillor McKee will forget about wondering where the money went. And no, it's not planning matter. You might want to pursue that in a different forum. If we need to investigate whether or no the repairs were carried out, that can be done, but no here in planning committee, because we're here to determine a planning application. But the remainder of the question you might want to answer, Pat, in relation to whether or not 20 years is reasonable or no.
Thanks, Chair. The reason the application is described as a temporary period of 20 years is that is what the applicant sought. And certainly we don't consider 20 years to be temporary. However, that's what they sought. That's what we've described it as, and hence the recommendation.
Thanks, Pat. Councillor Dryborough.
Thanks, Chair. Having not given the applicant the opportunity to have a bit of discussion, we've then got to consider this application, and looking at the application, I can see no reason as to why we shouldn't go along with the recommendation, because we've not had the opportunity.
Thank you, Councillor Dryborough. Councillor Geddes?
I would certainly support that, sir. Having seen the slides, read the report, again, I would be more than prepared to adopt the recommendation to refuse on the grounds detailed.
Any member otherwise minded? Paula, please.
The committee has determined to refuse the application on the grounds as set out in the report.
Okay. Come to item 9, change of use, alteration and extension to barn to form 2 dwelling houses, Block A, partial demolition and erection of 3 dwelling houses, Block B, with associated car parking and formation of access. This is renewal planning permission previously approved under 10/P/3/0315 and 04/P/30787 at Wollaston, Dunscor. And Pat Hannis, case officer again.
Thank you, Chair. As the Chair mentioned, and as described in the description of the application, the proposed development has been approved twice in the past, and there are no changes to the proposed development. The application site is just on the edge of the B729 Dumfries to Moneyhive Road. This is a view from the south. The building subject to development is the cream coloured building to the right, and the slightly whiter building to the left-hand side is the village hall for Wollaston. This is moving further along the road and looking at the steading building itself. And panning right, looking towards the access and where the proposed 3 dwelling houses would go. This is standing within the compound itself and looking back at the existing steading, and panning right and looking to the village hall to the right-hand side. The steading building in the foreground that you can see there is to be demolished as part of the proposals. The site plan that was previously approved shows a courtyard parking area serving the whole of the development and conversion of the steadings on the left-hand side into 2 units and the erection of 3 new units on the right-hand side. These are the elevations of the proposed steading and the elevations of the proposed new build. There's been no change in policy since the original application, other than the adoption of the local plan in 2006 and more recently in 2013 the approval of the proposed local development plan. Furthermore, there's been no changes to the site other than site clearance and tidying. Objections have been raised by the local village hall committee. However, these objections don't relate to anything that hadn't already previously been considered, and for the reasons set out in the report, the proposal is considered to be acceptable and is recommended for approval.
Thanks, Pat. Any members have any questions for the planning officer? Okay, there are no objectors, but we do have Homer Young, who is the agent, and he wants to speak to this application. You have 3 minutes, Mr. Young.
Thank you, Chair. My name's Homer Young. I'm agent for the applicant. I've really got little to add to Mr. Hanna's presentation, just some additional justification. Further, the 2007 application has been approved. We found ourselves in an economic downturn. There was an interested party at the time that was looking to develop the proposal. However, times got hard and they've currently withdrew. Prior to the previous consent expiring, my client, as is visually, aware, the yard was tidied. There was a submission of a staged building warrant for the foundations, and one of the previous conditions within the consent was that a soil investigation had to be, instructed and presented to the council. That has actually been instructed and was prior to the expiry of the previous application. However, this takes a little bit of time and we're just awaiting the results of that coming back in at the moment. We take note of the objectors' comments regarding visibility. I have to add that, the access road is actually without the application site. Measures are noted in the conditions that the boundary wall requires lowering to achieve adequate visibility for the proposed site, which will in turn improve the visibility to the access to the hall. There was also a lean-to building on the end of the steading, in the corner at the junction of the access to the hall, which has actually in fact been removed due to its derelict condition, and it was a danger. Just maybe one other point to note is that the access road mentioned by the objectors to the village hall is actually owned by the applicant. It's under his control, and the hall is actually owned by the applicant's father also. The committee have use of the hall, but and a pedestrian right access down there. At no point, has permission been granted or has the existing yard been used for parking to facilitate the hall. Certainly not with the consent of the applicant, so in terms of traffic movement and parking facilities within the site, there's no change to that because it was never permitted previously. Thank you very much.
Thank you. Do any member have any questions for Mr. Young? No? In that case, thank you, Mr. Young. Just resume your seat. Members are now in session. Councillor Dryborough and Councillor McCaughey.
Just short and sweet, Chair. Approve subject to the conditions in the report, Chair.
Thank you.
Happy to second that, Chairman. I think it's a big improvement on the kind of mess that was there before when it was an agricultural yard, so I think the locals will be happy with it as well.
Thanks, Councillor McCaughey. Agreed unanimously. Thank you.
Committee is determined to approve the application subject to conditions as set out in the report.
Thanks, members. We now come to item number 10. erection of dwelling house with integral double garage and installation of septic tank and soakaway at MOD Observation Post 50, Port Patrick. Case officer is Peter Barker.
Thank you, Chair. I'll just run through the slides. There's a fairly comprehensive report in front of you which covers most of the issues, and I'll pick out some of the key points afterwards. The application site is just outside the settlement of Port Patrick, on the cliff edge, as you'll see from the location plan ahead of just on the screen there. The site, on the cliff edge, with the golf course on the in the sort of white area just behind the text box there saying application site, and as you see the settlement down to the bottom corner. The proposal is to build essentially an underground stroke semi-underground dwelling with seaward views. The site's occupied by a building which we'll see the slides of in a minute, but essentially I'll just run through the concept of the proposal. As you can see, it's sort of fairly modest accommodation, 3 bedrooms, garage, living room, just sort of as I said, fairly modest. The design itself, you'll see from the report that the application has been the subject of pre-application discussions. So the design concept was furthered with the help of officers to evolve into the sort of design which we now see. And you can see from the cross sections in the elevational drawings in particular, the concept of the dwelling being semi-sunken, quite depressed in the landscape, lacking any sort of verticality, and obviously being so quite horizontal, therefore, in the landscape and at the cliff edge, and the windows themselves actually being, effectively, I think I described it in the report as akin to sort of battlements, in the military structure, just sort of being like slits in the grass bank around the edge. Just some further cross sections and just showing some further illustrative drawings of what it is intended to look like. This is the next suite of photographs. This is just an example I picked up on my travels. What I'm trying to illustrate here is the principle of a similar dwelling built underground on the cliff edge, but in this case it was built in the design is in the context of its surroundings, which is a little bit more southern or semi-Mediterranean, in style. But it just shows the general concept. That's the roof of the dwelling, with like a little glass atrium just popping through the grass. The naked eye not really detecting it, and you can just see a chimney just popping up by the tree there. And that's an example of a larger type of opening, which in this case sort of faces the sea. So that's the general concept, showing the low depression and the sort of semi-stroke, fully underground nature of the actual dwelling. Turning to the site itself, it's occupied by a former Coast Guard or military lookout post, essentially a prefab building with radio mast adjacent, quite derelict at the moment, as you'll see from the shots coming up. But this view just illustrates the sort of precipice type location of it, and it overlooks this gully here in the cliff, and the little rock out there is called Northwich Rock. But essentially, that's the general view from the from the site. So it's right on the edge of things. Going a little bit closer to the site now, you'll see the nature of the building itself. Just on the right there is the access to the site, which is also part of the Southern Upland Way, and the Southern Upland Way is shown to actually just continue over the bank there, that sort of sandy-coloured type path, and the golf course being just on the right, just going off the picture edge on the right there. Just coming a little bit closer, just showing the general condition of the building itself. just going a bit further round, just fairly derelict, fairly neglected, and essentially has no further use. The use has been abandoned. And the north elevation, north and east elevations, again, showing the views out to sea that the plot could potentially afford. The mast, probably 20 to 25 metres tall. And just sort of taking a little step back, standing on the Southern Upland Way there, looking back towards Port Patrick, you just get the relationship of the site to the actual edge of the main settlement, with the rows of buildings in the central middle ground there being Murray Villas and Coast Guard houses. That's essentially the proposal. The crux of the matter, as well as the design, is the principle of the scheme, because we're in a stage where we're probably in a bit of a grey area in terms of the timeline of policies. The existing or older, the existing policies, i.e. the local plan and structure plan, are quite old, and they do, in some respects, direct us to refuse the application because it's a new dwelling in open countryside. In other respects, it encourages us to allow the application because the proposal is seen as a means of tidying up a brownfield site. On the other hand, also, there's newer emerging policy. There's the new local development plan, which effectively will give greater encouragement to development such as this. But as it hasn't been through the inquiry stage, etc., it doesn't attract an awful lot of weight at the moment. But also in tandem with that is the new SPP, the Scottish Planning Policy, which does actually give a lot more emphasis to encouraging proposals of this ilk. Therefore, on balance, the proposal, the recommendation that we've come to is one to recommend approval, which technically, as it stands at the moment, would be a departure from the current development plan. Thank you.
Members, Councillor McKee.
I think it's a day for moaning, Chair. Why has the MOD never been instructed to either use that site or to clear it? See, it's been there since, what, 1945? Anyway, and so 1.3, you've got the sites located over 200 metres from the nearest third-party house. And in 1.5, 2, the site is some 90 metres from a settlement boundary. Which one's right?
Right.
The settlement boundary is not necessarily near his house.
I'll just see if I can just describe the relationships from the picture here. I mean, essentially, the distance from the existing buildings to the white properties, which you see, is approximately 200 metres. The settlement boundary of Port Patrick is actually, as shown in the Wigton local plan, is actually midway between the two. It actually follows the northern side of the other radio station, which you can just see the mast of, just to the left of the existing mast to the subject site there. So that's really why those two measurements are as such. I hope that helps.
That says, but it along a temporary period, 20 years.
Okay, any other member? Councillor Maitland.
It's not entirely clear to me about what the arrangements are for parking. You know, the building itself, one can see, will fit very neatly into the arrangements, the ancillary.
Peter, do you want to respond to that?
Yeah, if I could just bear with me, I'll just flick back through a few slides here, back to the original site plan. Yeah, the parking arrangements, just looking at the two plans on the left of the slide there, essentially the access is, yeah, well, where David's highlighted with the arrow, that's the parking stroke turning area. And vehicles will actually sweep off what is the Southern Upland Way, the tarmac section into that sort of courtyard area. which itself would be a depression just behind the actual building and generally below ground level.
May I? Just so to be absolutely clear, there will be a dip. There will be excavation. Then you're saying?
Yes.
Yes,
Yes, there will, because because there has to be access to the garage area, which is the large white square off the northwest sort of quadrant of the courtyard there, and the garage itself is underground. So, by virtue of the respective levels, it has to be at a lower level.
Okay, any other member? Any questions at this stage? In that case, we have one objector and then an agent. Mr. Robert Miller, please. And you have 3 minutes, Mr. Miller.
Thank you, Chair. Good afternoon. I'm Robert Miller. I live in Portpatrick at Murray Villas, Coastguard Houses, and I've got a prepared statement on behalf of all the other objectors, and I'll just proceed to go through this for you. Considering the amount of individual and well-researched letters of objection relating to this proposal, we feel our comments within the planning report are understated and do not fully reflect...
Mr. Miller, would you be kind enough to pull the device closer? Members can't quite hear what you're saying. Thank you.
Okay. Considering the amount of individual and well-researched letters of objection relating to this proposal, we feel our comments within this planning report are understated and do not fully reflect the range of issues raised. The report itself looks very heavily weighted and biased towards only the design element of the proposal, but there is not much emphasis on where it fails to accord with relevant development policies. Despite this application's complete failure to comply, it's worrying to now find that the planning recommendation is now seeking to look to depart from policy, but without any credible or qualifying evidence to back this. And we question why, when this is fully inconsistent with the Council's previous refusal, and is highly questionable when the application still continues to fall short in so many areas. The building is mentioned in the report as being a World War II relic, but we believe this is incorrect. The building's history is a little bit more recent than that. One of our local objectors worked on that neighbouring site there and witnessed these buildings being assembled in the 70s. So, in terms of planning history, they're recent. The report also comments on the site as showing signs of neglect and is considered something of a local eyesore. And of course, this is a matter of opinion, but if it's to be seen as a planning matter, then apply planning influence and look to remove the building. We shouldn't be looking for reason to simply replace it with another inappropriate development which doesn't accord with any policy. The report further bolsters this claim, stating that abandonment or neglect cannot be condoned or allowed to act as justification to allow unacceptable development, and we agree. Scottish planning policy advises that the planning authority should be directing development towards sites within existing settlements, and where the development is designed to fit the landscape setting and result in cohesive grouping. This is clearly not the case here, and is therefore contrary to national guidance. The planning report also mentions the site lies close to Portpatrick's settlement boundary, but fails to make it clear that the site is actually outside that boundary. And as defined in the Wigton local plan, this represents sporadic residential development in the countryside, and is again clearly contrary to policy. In conclusion, there is no record of any previous housing on this visually sensitive site, and just like the previously failed application, there are no claims of special justification or planning needs. The proposal does not reflect any local need either. In this village, everyone knows there's no shortage of available housing. In fact, it's safe to state that the village is already in danger of becoming overdeveloped with speculative proposals.
30 seconds to go, sir.
As confirmed in the report, the previous attempt to develop the site with the same proposal has already been rejected because of its complete failure to accord with established policies. Quite frankly, nothing has changed since. In line with the previous rejection, the facts are clear. There are no planning or any other justifiable reasons to support this application. The proposal falls way short of compliance and the planning argument is indefensible. We sincerely hope that the committee will agree with this. Thank you.
Thanks very much. Any members have any question for Mr. Miller? In that case, thank you, Mr. Miller. If you'd resume your seat, please. We now have Gordon Jameson on behalf of Robert Potter and Partners, who is the agent for the applicant. You have 3 minutes as well, Mr. Jameson.
Thank you, Chair.
My name is Gordon Jameson, representing Robert Potter and Partners Architects. My practice is acting as architect and agent for this applicant. I have a very brief statement to make to the committee. Robert Potter and Partners support the contents of the case officer's report and agree with the recommendation for approval subject to conditions. Thank you very much. Take some questions.
Certainly very brief, sir. Thank you. Members have any questions for the agent? In that case, resume your seat, please. Thank you. Members now in session. Councillor Geddes.
Well, as far as I'm concerned, sir, I'll come straight to the point. To me, it's a creative, not to say innovative proposal. In fact, I personally am reassured that we seem to have lifted our horizons considerably beyond the concept of the traditional Wigtonshire rural cottage. Because that is anything but it's designed, as far as I'm concerned, well designed to suit the site, and I have no compunction, sir, and moving, in fact, will grant the application on the basis detailed in the report.
Thank you for that, Councillor Geddes. Councillor Nicholl.
Yeah, I have no problems seconding that. In fact, I was in the Hebrides in the summertime, and I saw quite a few of these properties built like this, and they can be very attractive and are secluded on a but still having tremendous views over the sea and areas round about. So I have no problem seconding Councillor Geddes.
Thanks for that. Councillor Maitland, then Councillor Dryborough.
Thank you. I do think we have to recognise the concerns that objectors have with respect to following our policies, but we have in the past departed from our policies when there's been good reason to do so, and I think the report gives a very balanced approach to this. I do accept that objectors have perfectly valid reasons for coming to us to saying that they're not absolutely with our policy, but nevertheless, I'm in agreement with other members who say that on balance, this is definitely an improvement on what is there now. It is very encouraging to see this sort of thing coming forward, and I'm very glad to be able to support this, Chairman.
Happy with that, and I don't think we're describing it as a departure from policy. I think we're just describing it as an approval. Councillor Dryborough.
Exactly that, Chair. I was going to suggest a deferral until a site visit, because that's where I'm going to start my sponsored walk next year. But there
That's fine. Councillor Garroch.
Yes, well, it's just to follow on from Councillor Maitland, actually, because I think this is a departure from policy, and I think we have to lay it out very clearly why we're doing it, and I don't perhaps think that we have done that yet, and I would ask perhaps one of you to do that, because I think the objectors have very sound reasons. Can I just say that when I saw those pictures come up, I did go, hallelujah, for a little bit of modern day architecture. So well done to the planners. But I do think we have to be very clear why we can approve this if that is what we do.
I think 415 on page 910166 does that. It does that well. It just doesn't happen to say we're departing from policy. It gives out clear, concise reasons why. And personally, I as well like the idea of moving away from boxes. I mean, they're fine in their own place, but being innovative, I think, is helpful in some cases, and this appears to be one of them. So we have a... Oh, Robert, would you like to say something?
Just a comment, Chair. The way the report's crafted, we've obviously got paragraph 4.1, which is a standard paragraph, but then 4.2, we felt we should really set our stall out, if you like, with regard to the planning history. And, you know, it says this planning application is contrary to the terms of Structure Plan Policy D4, Local Plan General Policy 15 and Local Plan Policy SR21. So very early on in the report, it does recognise it as a departure from those policies.
Okay. So are members happy to approve this application? Okay. Paula?
Committee is determined to approve the application subject to conditions as set out in the report.
Thank you. Come to item 11, the erection of 2 polytunnels for agricultural use at Mouldy Hills, Canonbay. Planning Officer is Carla McWhinney.
The proposal is for the erection of 2 polytunnels to house sheep and lambs within the steading of Mouldy Hills Farm. The first slide highlights the location of the application site within Mouldy Hills steading, approximately 450 metres south of the public road, which is just above the runs just along the blue line at the top of the map. The block plan shows the position of the proposed polytunnels within the steading. Existing agricultural buildings are located to the west, north and east, and the farmhouse is located to the south. This shows the side and end elevations of the proposed polytunnels. This shows the access road to the farm. The picture was taken facing south from the B6357. Standing at the entrance to the steading facing north, there are existing buildings to the west. These are the existing buildings to the west of the application site. Standing in front of the farmhouse facing north, this overlooks the application site. Again, panning slightly to the right. The final slide shows the existing building, agricultural building to the east of the application site and part of the farmhouse. Thank you.
Thanks, Carla. Do members have any questions for the planning officer? No? In that case, we have a number of objectors. First objector is Diane Badham, and you have each of you will have 3 minutes.
My name is Diane Badham. I'm objecting in this instance to the planning process as pertains to this application. This application was initially processed by the planning department and a minor amendment required as to the footprint, which would imply routine scrutiny by the planning department had been undertaken. It was then accepted, processed and subject to public consultation. We prepared formal objections and submitted highlighting fundamental failings and inaccuracies. No purpose was stated in spite of a requirement for detailed information. Polytunnels were described as having concrete walls and roof. Only after having received the objection did the planning service case officer then make informal contact with the applicant's agent in a casual, informal email exchange on first-name terms, which subsequently led to alterations and resubmission, still with only limited information. To me, this process suggests 2 possibilities. It could be that this is an unusual catalogue of errors. Failure to undertake rudimentary checks as to the validity of the original application could be exceptional and maybe doesn't reflect common practice. Or it could be that the laxness demonstrated typifies a lack of rigour and transparency in the application and interpretation of the planning regulatory system. It may evidence inappropriately informal and close relationships between this applicant's agent and the case officer or wider planning department.
Mrs. Badham, just before we go any further, you realise the opportunities presented to you to address the council on material grounds, and your opinion of how this process has been arrived at isn't a consideration for this committee. It would be helpful if you could outline what your objections are. If that is your objections, there is a process to go through, but it's not today, I would suggest.
The objections are that the planning committee may be being misled, and there's a possibility that the system, the planning system, is being subverted. We believe that the farm at this location has no tenant, no need for permanent polytunnels, and is at the centre of and linked to a commercial gas field proposal. And we urge the committee to reject this application.
Any member have any question for Mrs. Badham? Thanks, Mr. Badham. If you'd resume your seat, that'd be fine. We have Mr. Frew, who is now marked in for 4 sessions. Mr. Frew, do you have 4 different presentations to make?
I will make one
presentation, Chairman, and maybe slightly over 3 minutes, but no more.
I'm very grateful to you for that. Thank you, sir.
Thank you. I appreciate the opportunity to address the committee, and thank you for that. My name is Bill Frew. I'm a local resident, and for the sake of transparency in this discussion, I'm also the chairman of a local residents group called the Campaign Against Coal Developments in Canterbury. My reason for objecting to this particular application, and if I could ask for the first slide, please. I apologise for the quality of the map, but the ringed circle almost at the centre of this slide is Mouldy Hills Farm, which is the subject of today's application. The red dots consist, and I'll explain the relevance a minute and why I believe them to be material, are the coal bed methane sites for which Buccleuch Estates and Dart Energy have planning permission to extract coal bed methane. In a private briefing, if I could call up slide 2, please. In a private briefing to politicians, including councillors of this council, on the 23rd of September, the chief executive of Buccleuch said, amongst other things, that they wanted to bring from the coal bed methane extraction CO2 for horticulture, a data storage centre, and create the infrastructure for industrial estate. And
Can I just clarify something, Mr. Frew?
Yep.
This application is for 2 polytunnels for
the
agricultural use.
I assure you the relevance of these comments will draw together to the polytunnels.
This is Councillor Driver.
Chair, I was at this meeting, so therefore should I declare an interest, since the objector has actually raised this?
Well, I'm interested to see what association it has with polytunnels to see if there's a different a direction, because clearly...
very briefly, I'll come to that point.
Because we have a decision to make today
Yes.
that is not related at all to methane collection or to any energy park.
Well, I will contend that it is, and it would be for you to decide whether that's the case.
Okay.
Yeah. So that an area around Mouldy Hills as an energy park. That is a quote from the Buccleuch Estates energy manager. In terms of Mouldy Hills Farm, the subject where this application rests, we understand that there's no tenant. We also understand from the Tenant Farmers Association that this is one of 9 farms that are vacant in this corridor, immediate area. We also understand that it's Buccleuch policy to require tenants to undertake the erection of their buildings. And we see no reference in this application to Buccleuch intending to take this farm in hand. A polytunnel for sheep and lambs, and I'm not a farmer, and there may be some here, would be required perhaps for 2 or 3 weeks, March and April, during lambing season. For the rest of the year, what are polytunnels for sheep and lambs for? That's, in my opinion, relevant to this application. But it's also the applicant's considered opinion that they've got alternative proposals for this specific site, and they include intensive horticulture. And I would contend, and it was for you to judge, that polytunnels on this site would create a precedent for horticultural activity, that this applicant can come back at a later stage and say that that precedent has already been created through the planning process. I therefore, for that reason, would ask you to consider either refusing or deferring this application so that the applicant can make more transparent his complete proposals for this and other sites in the Canonby area, so that the people can understand what's proposed, and you as the planning committee on our behalf can give proper consideration to all the proposals. Thank you.
Thanks very much, Mr. Frew. Members, any questions for Mr. Frew?
Can I get clarity on that question I asked you, because I was at this particular meeting that was mentioned in the objectors?
No, in my view, you have no reason to declare an interest and leave the meeting. We're here to determine a planning application that's for polytunnels for agricultural use. Any suggestion or inference that they can be used for another matter is something that would come before members at a later date if the applicant decided to do that. And we're not discussing neither an energy part nor energy extraction, CO2 extraction. We're discussing only the application that was before us today. And we also have an enforcement process if the applicant is successful in getting permission and decides not to comply with the conditions. We have an enforcement process to deal with that. But in my view, you have no need to declare an interest, but I'll defer to Paula for professional guidance.
Unless you consider that you said something that is pertinent to this application, it would be taken as predetermination. No, attendance at a public meeting on another matter would not be a conflict of interest.
So if there are no questions for Mr. Fu, thank you very much, sir. Members now in session. Councillor Dryborough.
Thanks, Chair. There was mentioned during the first objector there about the relationship between Buccleuch Estates and the officer. And I'm quite concerned that statement has been made in a public meeting, because I know that the planning officer is very good at her job, and she tries to and you know, gets all of this planning policies and procedures in place before that. So I'm concerned that a member of the public is actually saying there's a relationship between Buccleuch Estates officer and herself. That would concern me for that going out in public. So I would hope that can be stricken from the record, because I don't see that as a pertinent point.
Well, in my view, it's wholly appropriate that an officer communicates with an applicant or agent at every juncture that he or she sees appropriate to gain enough information to provide us with a detailed report and an accurate report. And in that respect, I would suggest that our case officer has done exactly the right thing in exactly the right way. The interpretation of whether that's accurate or not doesn't really matter, and it won't change, because we always, and I know we do, we always consider these applications on their merit, nothing to do with what might happen in the past or whatever conjecture might be placed upon them. Hey, Councillor Thompson, Ted Thompson.
Thank you, Chair. I think you've correctly identified that we deal with what is in front of us. I think it's a very straightforward matter, and I would move that we go to the recommendation to approve unconditionally.
Thanks for that, Councillor McCaughtrey. Oh, sorry, I think I missed out Councillor Maitland, did I? Sorry, Councillor McCaughtrey, with your indulgence. Councillor Maitland, Councillor McCaughtrey, then Councillor McComb.
Pearls before swine. Now, what I wanted to say is that the perceptions, I think, are important, and you know, I do accept that it's very important that people maintain a proper professional distance so that the public are reassured that there should be no possible inference of anything wrong. That having said, I can't think of a better place to put two polytunnels than is plonked in front of us today in the centre of a farmyard like that. I can absolutely concur with Councillor Thompson's views, which is that this is quite a simple application and that we ought to agree the recommendation as set out in front of us.
Are you seconding Councillor Ted Thompson's proposal? Thanks, Councillor Maitland. Okay, Jim McComb.
Thanks, Chair. On the basis of the evidence presented to us, I can see no valid planning reason to refuse this application.
Thanks for that. Councillor Groom. I'm not having a good day. I have him logged down here, but I thought he'd withdrawn. I thought he'd withdrawn when Councillor Maitland stepped in front of you. Sorry, Councillor McCaughtrey, then Councillor McComb, then Councillor McComb's been McCaughtrey, Groom and Gilroy.
Speak for what I was going to say there, Chairman. I don't have a problem with the recommendation. I don't know if we need to put a condition in just to satisfy some of the fears. Could you say it granted only for the for sheep and lambs? Would that be pertinent to include that?
The problem with that is what happens if it's two collie dogs in it to live. No, I don't think, maybe that's not appropriate, but what... David?
What you could do if you feel it's appropriate, and we do this from time to time, is actually have a condition saying that it shall be only used for the purposes of agriculture as defined by Section 277 of the Town Country Planning Act, which is a fairly common thing where we're in any doubt as to whether or not it's going to be used for that purpose. So I'd have no objection to that being added.
I'd be happy to move, we include that if the move on second to accept that. I mean, I appreciate the people in the area have got qualms, but you know they've got to appreciate that the planning officer is only making a decision on the basis of what the application says. She cannot make decisions on conjecture, rumour, paranoia that the objectors might have. So I think that they should think carefully what they say about our planning officers.
I think we'll strike that for the record as well. Councillor Thompson, are you happy to have a condition placed? Councillor Maitland, you are as well, okay. I'll try not to get confused anymore, I'm confused already. Councillor Groom, please, and then Councillor Gilroy.
Just to say that I quite agree that it is a very simple measure in planning terms. I'm quite happy to support it.
Thank you. Councillor Gilroy.
My concern was that how we differentiate between agriculture and horticulture, but if we put that condition in, that would alleviate that concern for the objectors. I'm quite happy for that.
Happy with that. Thank you, Councillor Carruthers.
It's the exact same point. Does that exclude horticulture at that point, to that section?
Well, if horticulture is different, yes, it does. I think it's an application for an agricultural use. If horticulture and agriculture are different, then a separate application have to be made. That's not to say it won't happen, that's not to say we won't consider it, and that's not to say we might make a determination if that happens, but that's not for today.
What was contained within the Act, or the actual policy referred to as the Section 277.
We're having a discussion here. Apparently agriculture will include crop growing, so it may be that there is a further debate to be had about what exactly is determined or suggested by agricultural. However, if it encompasses crop growing, then that appears to be what we are determining today, that it's an agricultural use this polytunnel is to be used for, and it may include crop growing, although that's not what the applicant says that they want the structure for. Members happy with that? Okay. In that case, Paula, thank you.
Committee is determined to approve the application subject to a condition limiting the use of the polytunnels to be formed to agricultural use as defined in the Town and Country Plan Scotland Act. Town and Country Planning Scotland Act.
Thank you, Paula. Okay, we come to item 12, erection of dwelling house, formation of access, turning area and 2 car parking spaces at Boundary Cottage, New Abbey Road, Dumfries, and the case officer is Andrew Robinson.
Thank you, Chair. Yes, this application is for a erection of a single-storey dwelling house and formation of access, turning and parking facilities at the site for 2 car parking spaces. The site is located on the eastern side of New Abbey Road, just as you come out of Dumfries, on the southern boundary of the settlement boundary, and it's highlighted in red on the slide. The site is actually located on the left-hand side of the road, where the site between the wall and where the footpath ends, just beyond the speed limit sign. This is looking north back into Dumfries, which shows the footpath which has been recently laid in the last year. In terms of the site, this is looking down into the site where the land levels drop quite dramatically from the road. To the rear of the site, there's a concrete surface there which indicates where a previous house was on the site some years ago. The trees at the rear of the site are part of an ancient woodland and located in the rear garden of one of the neighbouring properties. Opposite the site, these are the 2 nearest neighbouring properties, Priestland's Bungalow and Priestland's Cottage, located on the other side of the road. This is actually taken from within the site, and it just shows the extent of the land level drop. This is actually taken from where the proposed driveway and access is into the site. And to the north of the site, this is number 4, Ewart Drive, which the rear garden of this property backs onto the northern boundary of the site. In terms of what's proposed, the top elevations show what's proposed now, and the bottom slide elevations show what was previously submitted with this elevation, and it just shows the extent of amendments made to the application in terms of detailing where officers felt it was appropriate for the design to be improved, with some integral features such as skews and coins onto the walls. This is the site plan. It shows the access and the road, the driveway into the site, turning area which is appropriate so that cars can exit the site in a forward gear, as well as 2 car parking spaces and soak away to combat drainage arrangements. This slide shows the sections just to give an idea of the levels on the site, which shows the amount of land regrading that would be required in order to accommodate the house. So the bottom hashed line shows where the existing land levels are, and then the sort of more solid line shows what's actually proposed for the new site levels. This shows a site level of the proposed driveway, which demonstrates that the first half of the driveway would actually be on par with the current land levels, and the main regrading would actually be at the rear of the site, which you can just see the difference between the hashed line and the solid line is actually a distance of 0.8 metres of a raise. And a landscaping plan's been submitted, which effectively shows that it's proposed to have grass and hedge planting. 6 trees would be retained within the site boundary, and 3 more would be replanted in the northeastern corner, which is demonstrated on this plan. In terms of the planning history, members may recall that this was actually determined at the Planning Applications Committee on the 28th of November last year, and the details of that's highlighted within the report on paragraph 1.6. But just to recap, the refusal reasons are within the report for why it's refused, and this was the scheme that was refused at that time, and it just demonstrates that the scheme has been scaled back since this previous submission, and also the amount of land regrading as well has been scaled back as well, which is demonstrated on this slide. And finally, there was an approval in early 2008 for a house at this site during reserved matters application, and this slide does show the extent of the house that was approved. Although this time expired and was never implemented, it's a material consideration that the design of this house was approved under current Nisale local plan policies. And just in conclusion, officers are of the opinion that this scheme is acceptable for the reasons stated in the report, and previous refusal reasons have been suitably addressed. Okay,
thanks Andrew. Do any members have any questions for Case Officer? Patsy?
It's just some of the objections from representatives, and it's mainly to do with the trees. And there seems to have been a lot of felling that was not really. I'm looking at under trees under 3.1 on page 105, 17, and also number 20. And I just wonder what you feel about this. And also number 21 failed to have regard to conditions previously attached. Could you?
Yes, there's in paragraph 4.2 there's a bit of an explanation about a previous condition that was attached. There was a planning permission, well, it was outline planning permission in 2003 was approved for the site with a condition about no trees to be cut down, but that condition will only come into play if the development was ever implemented, which it wasn't. So effectively that condition is irrelevant because it wasn't actually implemented. The trees are not protected by a tree preservation order and they're not in a conservation area. So from a planning point of view, there was actually no consent required to fell the trees.
Okay, Councillor Conroy. Anybody else have any questions for Case Officer? In that case, we have 2 objectors and David Fallis on behalf of Mr. Sharkey, the agent. So we have C. Pearson Harvey, an objector, for 3 minutes, please, sir.
Thank you. My name is Pearson Harvey and I live at number 8 Ewart Drive, which doesn't exactly join onto this property, but I am affected by it. I've got 2 major concerns. The first is surface water. The second is wind damage. Any development will increase the runoff from Boundary Cottage to neighbouring land. To say that the land at the bottom of Boundary Cottage was dry after heavy rain may have been true on this one occasion, but it is not true at all times, because I've seen it, it's wet. Anyway, most of the water would have run off to number 6 by the time the visit was made, because number 6 is lower than Boundary Cottage. Removing the trees and thick vegetation has already made matters worse, and then using infill, a roof and drive will even make the matters worse still. I question the use of porous bricks and a soakaway in the long term. Surely these will silt up over time. The farmer behind us laid a land drain 3 or 4 years ago. That has now silted. It's become a lake again in that backfield. Also, the drive is very steep, and the rainwater won't soak through it, it will run off it, particularly in heavy rain. I accept that water will naturally run downhill, but why allow this development that will make an existing bad situation that we have even worse? The removal of mature trees from Boundary Cottage has exposed the trees in number 6 to the direct force of the prevailing wind. These trees have been weakened, that's in number 6, by the increased soggy ground. When the trees in number 6 have gone, my property will be fully exposed to the prevailing wind, and I've already lost 2 trees. I note that the recommendation of the planning report is subject to 12 conditions. Who enforces these conditions, and who do I contact if I believe that one or more is not being met? It's already been touched upon that there was a condition before that no trees within the site should be cut down, lopped, uprooted without prior written permission of the planning authority. This permission was never implemented, and therefore the requirements of this condition no longer applies. How do we make sure all the conditions do apply? Finally, why has planning permission been requested for a small dwelling on a plot that has been put up for sale? Surely any buyer will want to tear this plan up and request a new plan for a bigger house. I ask you to reject this planning applications on the ground that this steeply sloping site, situated in an area of known poor drainage, is not a suitable building plot. The only solution to this is to replant a full screen of trees in Boundary Cottage, and if the undergrowth is allowed to return, we will in time be back to where we started. Thank you.
Thank you very much, Mr. Harvey. Does anyone have any questions for the subjector? In that case, thank you, sir. Please resume your seat. And Ms. S. Scott for 3 minutes as well, please.
Thank you. Thank you, Chair. I reside at number 4 Ewart Drive. My late husband and I have objected to previous applications on this site, and whilst I note that the house has been reduced in size, I still have great concerns about the proposal to develop this site. As stated in our letter last year, we noted that the consent previously granted was subject to many conditions to safeguard Council's local development plan. The activities that have taken place in the site since the previous application have again attempted to set aside, ignore and dilute these conditions. If the proposal to remove permitted development rights, the Road Safety Report 4.18, is passed, I understand any further extensions or alterations would require further planning permission. Indeed, if the proposed foundations are moved 3 metres further back from the original site, and the proposed floor level raised by 0.3 metres, this would require a large amount of infill, which will aggravate drainage problems and will also make the house more obtrusive, which will have an adverse effect on an impact on my property. The 3-metre wide driveway immediately at the boundary of my property, which slopes downwards, states it is surfaced in free drainage. This will, without a shadow of a doubt, cause drainage problems in the future for my garden. The gradient access is 10%. It's very steep, and generally it should be no greater than 8%. The roads officer indicated that examples of this gradient of driveway exist, but I would argue that this access is a safety risk, considering this access is onto the new footpath and cycle path, which was never envisaged when outline planning was granted some 10 years ago. As far as the trees are concerned, I'm glad the planning department recognised that there has been a considerable felling of trees and removing of trees this summer involving diggers, causing damage to the boundary fence and number 6 fence and also the boundary sandstone wall, which leaves it in an unstable condition. I would argue with the planning officer when he says the condition 19 of the planning permission was never implemented, so the original recommendations were ignored. There was no ring fencing for protection of my trees and the retraining trees that are on the site. I note new recommendations for protecting trees are in place. However, my trust in this being implemented falls short.
You have 30 seconds left, Mrs. Scott.
Drainage of site. The agent states there's no standing water in the southeast corner of the site. I visited the corner site and the ground is soggy and wet. Again, it's very vague about proposals for drainage. There's been a bank of soil and rubbish deposited in this area when removing the trees, so I don't know how stable the soil is underneath. Why not have a professional educated soakaway test and calculation? The surface water will discharge into adjacent properties, which will be exacerbated by the increased ground levels, which would constitute a loss of amenities. Finally, I would just continue to say the new access point to the new Abbey Road is, I appreciate this house has been on, foundations has been on this site for many years, but under very different traffic conditions than we have today.
Thank you, Mrs. Scott. That's great. Thank you.
Thank you.
Does any member have any questions for Mrs. Scott? In that case, thank you. Resume your seat, please.
Thank you.
We now have Mr. David Fallis on behalf of Mr. Kay Sharkey, agent. We had a Mr. Klaus Blake registered to speak, but he doesn't appear to be present today. So we'll have Mr. Fallis and Mr. Sharkey. Thank you. You have the same 3 minutes, Mr. Fallis.
Thank you. Having listened to the representatives there, the matters that they raise have been fully and quite completely dealt with already in respect of the detailed report that's been provided for you. So I'm not going to get into a discussion in respect of that matter. The matters are all dealt with. It's fully covered in Mr. Robinson's report, so I don't think there's anything further to add unless anybody's got questions for me at the end. Historically, permission has been granted in principle by the council over 10 years ago. A particular design has already been agreed. An alternative design for that was submitted and that was subsequently refused. We came in last year having moved away from the approved design for that 07 application. We moved away from it because there was no need for a house of that size at the time, so we sought to try to downsize the thing. Obviously, that arrangement, which had been discussed with the officials and they seemed to be agreeable with it, was not acceptable to committee at the time. We've gone away, looked at the reasons for refusals, looked at the history to try to find some sort of agreed solution that can accommodate the needs of the client and still overcome objections of the committee and adjoining parties. This is a classic scenario where nobody is going to win, not everybody is going to win out of this. The parties round about have objected to all the applications and we can just take it as read that they're not going to be agreeable to this one. What we are stressing the fact is that the principle is acceptable for a housing on this site. The design that we've come in with is a great deal more simpler and plainer from that has previously been approved, has no greater mass, or in fact it's probably got less of a mass and impact and imprint than the other agreed solutions to it. And as for accommodating the application on site, well, the soakaways will improve the situation. There's a lot of comment being made about the loss of trees. Well, none of the trees were specimen trees. A lot of it was regeneration, regrowth, sycamore, poplar, no specimens, nothing of any great note. If anything, attention was required to it. In agreeing to a house being put on the site 5 years ago, in fact, indeed 10 years ago in principle, the council accept some of the trees will have to go. The majority of them that would have been affected by the development have been removed. Peripheral trees have been retained. Supplementary trees are being proposed as well. And with regards to the fact that, the trees are gone, therefore all water will run away down to the adjoining parties, there is, grass, shrubs, there are other plants being put in place that will help retard that aspect of it. There's an inherent problem of drainage down there. It's not going to be aggravated by the situation here. Indeed, it may in actual fact ameliorate it with the positive catchment arrangements being put in place.
Thank you, Mr. Fallis. Does any member have any question for Mr. Fallis? Councillor Crothers.
Well, just a brief one in regards to the touching on the drainage system. I suppose it'll be a sustainable urban drainage system will be put in place. Just the maintenance and that, how will it be upkept?
It's in the client's interest to make sure that it works and is effective. If it starts getting a wet ground, he's got no use of his garden area. It's not in his interest to allow that to actually occur. We are putting into place, there's greater capacity to retain water there with regards to some areas being raised up. But again, falls are being changed to take it as far away from the neighbouring properties as is possible with regards to the confines of the site. But again, it's an accommodation measure. It's part of the development that was implicit when the original schemes have been approved on the site itself. And obviously, if the surface water systems are not working, it's going to affect his property, and therefore, it affects him. So it's in his interest, like any other house owner and user, to maintain their property.
Thanks for that. Any other member for Mr. Pallas? In that case, thank you, sir. Just resume your seat. Oh, sorry, I didn't realise Tom was wanting to speak. Sorry. Tom McCaughey. All right, sorry. Thanks, Mr. Fallis. Thank you. So we're in session, Councillor McCaughey.
Well, I wonder if you put up the slide with the access to the site and its relation to the New Abbey Road. So, is that going to be site access there? Right, that's fine. I mean, I'm actually minded to refuse it because this has been a long-running saga, this, for those who've been in the planning committee for a long time. It comes along, gets permission, then they decide they want to expand it, we refuse it, they take it away, they come back again. I think it's been one of the longest-running sagas in the planning department ever. I still think there's reasons for refusal. What concerns me more, if folk are minded to grant it, and it ties back to some of the issues that came up in items 5 and 6 earlier on, and also across the road there, just further down from East Cottages, there's Priestland's Farm, which was granted permission to be converted, all the outbuildings converted into housing. There's conditions there to do with putting footpaths in along the verge, etc. These conditions have never been implemented, nobody has been prosecuted for them, and I worry about putting these conditions on. And all the conditions we put on are the same, and that will include the access to the site, which is going over a pavement which we just laid last year and put a new path in, and you can see the applicants driving over it. Now, we've no say as to whether he's going to drop that pavement. It'll be in the conditions somewhere, but I can't find it, that he should drop that pavement. But what concerns me more, all these conditions we put in, it always stipulates that the dwelling house shall not be occupied until these conditions are done. I'd rather see us have conditions where they cannot even start the development to put conditions in, particularly things to do with dropping curbs, putting in street lighting, moving the 30 mile per hour limit, because I'll guarantee you, as we've seen with the previous applications today, we can put these conditions in, the developer will not do them, and they'll never be enforced, because the developer sells the property on, and we get into legal battles. So I just wonder if we can change these conditions, particularly pertaining conditions 7, 8, 9 and 10, that it's changed from an occupancy to a no construction. So there's nothing to stop the developer putting in street lights and 30 mile per hour signs, dropping curbs, etc., before he actually goes into the site. And that guarantees us, as the Roads Authority, that our rights are being defended. And I wonder if we can do that. Because the previous record for putting these conditions on an occupancy rather than a development don't seem to work.
I have a funny feeling that won't happen today, because that'll be a policy change that we'll need to introduce whereby we require certain conditions to be met before construction. However, I will ask Paula if we can do that. I know Councillor Dick wants in, but I'll have Paula. All right, okay. David, you seem to be the expert on this one.
In short, you could, but you'd have to be sure that it met the 6 tests of conditions and whether or not it is reasonable to actually require some of the things that you mentioned there in conditions 7, 8, 9 and 10 to actually be done prior to development is a moot point. That if you make these changes, it's open to yourself to do so, but be aware that these conditions could be subject to either appeal or a further application to amend them. My view is that at least some of those, you're beginning to the realms of being unreasonable to require certain things to be done before you can actually do any development. But some of them you probably could competently do.
Okay, Councillor Dick.
Yeah, I recall this one last year when it was refused, and was considerably bigger development, if I recall. And I think in terms of consistency, I couldn't possibly now move to refuse a smaller development, and consequently I would have to, on the basis of consistency, move to approve.
Councillor Carruthers and Councillor McGee.
Actually, just picking up on Councillor McCockery's point first, and that was with regards to conditions. I think it wouldn't meet the 5 or 6, whatever parts of that test, and we need to be consistent across the board. We shouldn't be discriminating against a particular applicant. So, but the Scottish Government did look at that, and I thought that was sort of a fair way of going forward, and that was to put a completion certificate on a planning application. I thought that was a fair way, but they discarded that as far as I'm aware. I thought that would have been a way of actually enforce the condition properly without having to take it through the judicial system. I would agree with Councillor Dick in this case that we should move to approve as per the recommendations.
Okay, so we have a recommendation or a motion from Councillor Dick, seconded by Councillor Carruthers. I've now got Councillor McKee, followed by Councillor Maitland, Councillor McCockery after that.
Thanks, Chair. My concerns about the egress coming out for the site is a road level enough such that the car can sit level? Because given we've got the cycleway along the front of that house, if a car's coming up out of there at an angle, it'll not necessarily see a cyclist or a pedestrian, and there could be an accident. So we need to be assured that, I don't know, 10, 12 yards back for the edge of the pavement, inside edge of the pavement, is level with the pavement.
The Council's Roads Officer was consulted on the proposal and did ask for various extra information which was submitted throughout the course of the application to demonstrate, particularly there was an issue about whether cars would bottom out. It was the phrase that they termed in terms of how it would exit. The Council's Roads Officer hasn't objected and is content that the required visibility displays which are attached to the condition can be met, and that was a recommendation that they requested officers to put on in terms of that's what is considered to be a suitable requirement, and we're content that that could be met.
Thanks, Andrew. Councillor Maitland.
Well, it was really actually to support Councillor McCockery's concerns with respect to the 30-mile-an-hour limits and all the rest of it. I do understand that there's an argument to say that that has to be a change in policy rather than dealing with it on an individual way. But I mean, I think he's absolutely right. I can see exactly what's going to happen here. And I would defer to him if he wants to put something up to try and deal with the issue. Then by all means.
I think Councillor McCockery wants back in, so maybe he's going to suggest a way forward.
I mean, I was going to move refusal because I've got good grounds to refuse it. But I would say to those who want to approve it, I think we should learn the lessons, and I don't think it's a change in policy. It's something we probably haven't looked at in any great depth before, about we allow people to go ahead and put these conditions on that before you can occupy the property, this must be done, that must be done. The environment, I mean, as I say, the one across the road, which we granted about 5 years ago, supposed to put a footpath in all the way up the road there. They never bothered doing that. The folk who moved in there actually said, well, it's in their title deeds, there's supposed to be a footpath there. And it's never been enforced. You can never find the developer again anyway if it's a single individual. So we're putting on conditions. Either don't put any conditions on at all, or if you're going to put conditions on, don't do it on occupancy, do it on the development. That they put things at 30 mile per hour things, pavements, lights, get them in first. And then that is a statement of their intent. They're actually going to carry out the development.
I would have to say, Councillor McCarthy, if you're aware of breaches of policy, maybe bringing that to the attention of the officers before today.
We've just had two plan applications earlier on where nothing's been done about them.
But that's, by the way, we're not here to criticise what has happened elsewhere. That's another forum for that. If you have a proposal on how we take forward this application today, that will be helpful, whether it be a recommendation to refuse or how you put conditions on that you're satisfied with. But in terms of breach of conditions, that's another place and another forum. Councillor Dick wants to speak, and then I think that...
Well, I think, Chairman, I just move that we refuse it on the grounds that the siting and design of proposed dwelling house be out of character with the immediate semi-rural area. Proposed dwelling house would have an adverse impact on the amenity of the neighbouring properties in York Drive by the virtue of degree of tree felling and loss of woodland, and it would also be detrimental to the safety of the cycle path due to the elevation of the driveway.
While Paula absorbs that, I'll ask Councillor Dick if he wants to come in.
Just on the point that Councillor McCaughey and Maitland made regarding the 30 mile an hour signs, I don't know whether could I ask advice on whether a further condition could be put on that they are moved to take into account the new entrance of that building.
That is actually a recommended condition. I mean, the issue which Councillor McCaughey is raising, it is news to me. If that hasn't happened, it may well be just a handover and different officers that's not got picked up on. But if there are concerns that something hasn't been done, then I will take that away. I'll have a word with our planning inspector and look into it. If it's still within the time in which we can deal with it, you can take it from me that we will look at that, because we put these conditions on with an expectation that they will be complied with. And if they're not, then I can assure you our planning inspector spent a lot of time chasing these matters. It's not the case that you attach a condition and they don't get complied with. I wouldn't want to send that message out to the members of the public that just disregard conditions. That's certainly not the case.
Councillor Groom has asked to support a proposal by Councillor McCaughey.
I'm quite happy to second Councillor McCaughey.
So we have a motion to approve by Councillor Dick, seconded by Councillor Carruthers. We have a motion to refuse by Councillor McCaughey, seconded by Councillor Groom, and the reasons for the refusal. Is it competent, David? And what are they, Paula, please?
What I've got is basically, I think Councillor McCaughey was just actually reciting what's at the bottom of page 102 for the previous grounds, plus adding in that also on grounds of road safety because of the vehicles crossing the cycle path.
But strike out the footprint part on the first recommendation, because that's not appropriate for this particular development.
Okay.
So just to clarify, the proposed grounds for refusal would be the proposed dwelling house would have an adverse impact on the amenity of the neighbouring properties in York Drive by the virtue of the degree of tree felling, loss of woodland, and there would be a detrimental, unacceptable impact on road safety, vehicles crossing the footpath and cycle path.
And that's the amendment, Paul. The motion's to approve as per the report.
Chair.
Motion.
Councillor Dick.
Motion.
Councillor Blake.
Amendment.
Councillor Carruthers.
Motion.
Councillor Dryborough.
Amendment.
Councillor Gilroy. Councillor Groom.
Amendment.
Councillor Maitland.
Amendment.
Councillor McCaughey.
Amendment.
Councillor McComb.
Amendment.
Councillor McKee.
Amendment.
Councillor Nicholl.
Abstain as I was out the room for most of the debate.
Councillor Stephen Thompson.
Motion.
Councillor Ted Thompson.
Motion.
581. Yep, 5 votes for the motion, 8 for the amendment with 1 abstention. Committee is therefore determined to refuse the application on the grounds as set out.
Thank you, Paula. Item 13, external alterations and change of use of first floor office and store to flat at 19 White Sands, Dumfries. The recommendation is to notify Scottish Minister of intention to approve subject to conditions. Case officer is Andrew Robinson. Andrew, if you take us through the report again, please.
Okay, thank you, Chair. I'll just get the slides ready. Yes, this is a change of use of a first floor office of a building situated on the White Sands to a 1-bedroom flat, as well as external alterations to the building as well. Slide shows the location of the site on the White Sands, highlighted in red, which is situated fronting the White Sands and the River Nith, with Brewery Street located to the rear, and it's also in close proximity to Friars Vennel. This shows the existing and proposed plans, with the existing shown on the left and those proposed on the right. Effectively, there would be the replacement of the first floor front windows, the installation of an access door to the rear, installation of roof lights, and the removal of a dormer window. This is the property in question, situated above a hot food takeaway. Just some of the slides to show the surrounding locality. These are adjoining properties on the White Sands. This is the rear of the property, where an access door would be installed on the right hand side, and where roof lights and the dormer window at the top there would be removed. This is the rear of Brewery Street, and this is looking back towards the river, which is Friars Vennel at the bottom there. So essentially the key consideration in the assessment of this proposal is the level of flood risk against the economic benefits that the proposal would bring. The main concerns of SEPA and the Council's flood risk management team highlighted within the report that they've both objected is that the proposal would increase the number of people at risk of flooding and potentially put rescuers at risk. After assessing the proposal against relevant policy on flooding contained in Scottish planning policy and other material considerations, it's considered by officers that this proposal for a 1-bedroom flat is unlikely to be at significant risk of flooding, such to override the economic development benefits that it would bring. And this conclusion has been come to bearing in mind that the building is existing, the proposal is only for a 1-bedroom flat, public safety would not be materially affected over the present situation. Warning systems are in place on the White Sands to warn people of a risk of flooding that may occur. The planning history includes a previous grant of planning permission, as well as the economic benefits that the proposal would bring has put it in favour that it should be recommended for approval. However, if members are minded to approve the application today, it would have to be notified to Scottish ministers as a result of a statutory objection from SEPA.
Thank you, Andrew. There are no representatives for this particular item, so we're into session. Members, Councillor McKee, then Councillor Driver.
What height above street level is that back door? I notice there's 2 steps. Is there more than that inside?
I suppose if you look at the letterbox on the door on the left-hand side, it's probably looking at about roughly probably at least 1 metre.
Are we looking at a door with 21 on it, or the brown door on the right? I'm looking at the wrong door, I think. I thought it was number 19, this.
If you look on page 115, I'm not even convinced there is a back door. Hopefully Andrew's plans will show if that is the case. Because 21 is clearly the one that's next door. Then you've got, I think what you're saying in the plan there must be the one that's next door to that as well on the right-hand side.
Are we now installing a new door to the rear of the property? So it's no there. So Councillor McKee is asking what height the step is to get an indication maybe what the water level might be. But on page 1.2, page 117, I think it's part of the way down it talks about, or somewhere in this paper it talks about installing a new door. So the door's not there currently. Councillor McKee.
If you look at that plan, that's strange. It's 19 and 23 on that site that's highlighted, application site. Number 21's next door.
Maybe upstairs and downstairs, although my house is 66, 68 High Street and it's only one house with one door, and it's maybe a historic thing. Some of these old properties have, they're very modest in size, and as years go by, they're incorporated into a single building, so it's maybe something like that.
Of course, that 23 could be a Brewery Street number, Brewery Street number as against the White Sands number.
Yeah.
Sorry,
okay. No bother, right. Councillor Dryborough?
Just happy to go with the recommendations, Chair.
Okay. Councillor Maitland?
Sorry, I'm really sorry to do this because I'm not completely clear about this, but is there any opportunity in an application like this to do a bit of mending?
No. Well, by refusal you can if you want to then make recommendation to the applicant or the agent of what you'd want to see. But we're always rehearsed, and it's the same thing. What we have before us is what we have to determine. You can also make reference to or ask case officers to make comment to the applicant, irrespective of whether the application is approved or declined. But the only way you can make amendments to this is by refusing it and sending it back to the applicant or agent. I've got Councillor Maitland wanting to come back, and then Councillor Blake.
Yes, what I'm getting at is that installation of replacement windows with similar windows to the front elevation. Can we have a little bit more detail about what you're proposing? I mean, you know, we need to. It's not completely clear. I've looked at the pictures in the papers, but there actually isn't very much detail about what's being proposed to be put in. I don't know.
It shows an indicative type of window, and I suppose we could put a condition on saying we require a specific type. I just wouldn't want us to start redesigning something for an applicant, because that's not why we're here. Andrew?
Does condition 1 actually detail the details of the windows? So there is actually a condition already on about the style of windows. Maybe it might be open if any particular style is requested, and a condition could be amended accordingly.
Does that help, Councillor Maitland? Do you want to deliberate further, or shall I let Councillor Blake in the meantime?
Yeah, it's condition 1 on page 129.
Councillor Blake.
Yeah, just very briefly, I was going to try and give some explanation to the missing number 19. Surely they'll be numbered from the front in White Sands, and that's the back doors we're looking at. Not every property's got a back door.
Councillor Maitland's another thought, then we'll come to Councillor
Councillor Maitland just remembered she read that and then thought, panic, well, what does it look like? You know, less replaced by an exact replica. That's what I was on about. If they're an exact replica, I want to know that it's what I want to put back in again, or the rest of the committee wants to put back in again. Because if they're not right, then for heaven's sake, let's not have an exact replica. So, well, I haven't got a photograph in these papers.
Sorry,
well, guess what?
I should maybe make that clear. What this is saying is, what we're not saying is an exact replica of what's there. It is basically they have to submit a scheme showing what they're proposing in terms of the replacement windows. Thereafter, once they're installed, it's going to be installed and retained for the lifetime of the development. That's the new windows, the said windows, unless replaced with an exact replica. And that's meaning of the new windows, obviously, because what's there is not particularly good.
I misread what's going on here. Thank you for that explanation.
Well done, Councillor Maitland. Councillor McCaughey and then Councillor McKee.
Chairman, if you go to page 115, and you'll see the numbering problem we've got there. The application there, highlighted, is number 19. The paper shop next to it is number 16. If you go to the rear of the paper shop number 16, it's actually number 13 Brewery Street. And the rear of 19 White Sands, which is the one we're talking, 19 White Sands, which is one we're talking about, is actually 23 Brewery Street. So you can see the number there on the plan. And there are probably good reasons for that.
I'm sure there will be, but we'll try and explore it today. Councillor McKee.
Why, no, it's a sweetie shop, an ice cream shop there. Chair, you see, you know it's in the building, there's a door between these two buildings. I don't know whether there might be access in there into that building. And I'm sorry to harp on about it, but it's the height above the road level, at flood level, if you like, and given you say a foot of water. Is that going to get access into the house or not? I appreciate
it. Looks to me like an alleyway because
it
you
does,
can see the extraction fan chimney thing at the back. So
it's whether there's any access into the building for there.
Yeah, but that's obvious. The application doesn't make reference to that, so I'd presume that there isn't one. I presume it's simply a lane or a corridor or something.
Yeah, Chair, if you actually look on the bottom plans there, you can see there's a solid wall. There does appear to be one window in the side, but there's no door that comes in on the side there at all. So if that's an access, it must purely be for as a sort of just an access along the side for the flues as much as anything.
A bit of anything else with maintenance for the flue, because that'll be required at certain stages in the functioning life of the business. So we have a recommendation to approve. Is that unanimous, or do we have any dissenters? Okay, unanimously approved. Paula?
The committee is determined to notify Scottish Ministers' intention to approve, subject to conditions as set out in the report.
Thanks, Paula. Application number 14, item 14, reinstatement and alterations to 2 abandoned dwelling houses and 2 abandoned flatted dwellings at 1 to 4 Mill House, Kingham Quay, Dumfries. Recommendation: notify Scottish Minister of intention to approve subject to conditions, and the case officers married off. Mary, please.
Thank you. Yes, it is another one where we are recommending approval, but there is a SEPA objection to the application. In this case, it is at it's 1 to 4 Mill House, as you say, at Kingham Quay. These comprise 2 flats and 2 dwelling houses. As you can see, it is very close to the River Nith there and within the 1 in 200 year flood risk area. The application is to reinstate the dwelling houses, which the use of which has been abandoned probably around 2007-2008, when the larger site there, that's sort of in white, was the subject of an application to redevelop it for housing and flat development. Some of that commenced through the demolition of some of the buildings, and some of these particular dwellings were stripped out internally and services cut and so on. So this is why there is an application now to bring them back into use. There is another aerial view of the site. You can see the warehouses to the rear there, which were in the previous location plan. This is the 2 houses. These are number 1 and 2. This was taken in June, and I think it's been tidied up a bit since. But the proposal is to remove that dormer, which is on the roof, and obviously to carry out repairs. But other than that, there aren't very many alterations proposed. And these are to the right hand side there are the 2 flats which are part of the application. This is to the rear. Again, this was in June, and this is prior to being tidied up. And this is more laterally. This is the sort of rear yard area. It's really just proposed to sort of retain this area to the back, which isn't ideal. If it was to be a new house, it's not really likely we would want this sort of situation. But as the argument I've made in the report is that the houses are existing, and really it would be of benefit to see them come back into use for the area. And in terms of economic regeneration as well. This area is where the car park is proposed, which would serve numbers 2 to 4. And we're asking for that wall to be reduced in height to a metre, just to improve the visibility from the access. And this is the wall there. This is a street view photo here. So, in conclusion, the application, in fact, actually, some plans here. This is the block plan submitted by the applicant, which shows the layout of the site and the car parking arrangement. Elevations as existing and proposed. And that's it. So in conclusion, we are recommending approval of the application on the basis that the benefits of bringing the properties back into use override the flood risk that there is to the properties. And there are some conditions recommended as well, including one which removes permitted development rights, which would allow them to extend the properties. So this means that it doesn't affect the catchment area of the flood area, and also it means that there is a risk of contamination within the site as well, so there wouldn't be any disturbance of the ground in that case. Thank you.
Thanks, Mary. Does anyone have any questions for Case Officer Councillor Ted Thompson?
Thank you, Chair. Just on the relevant planning history on page 134 of 166, where you refer to the 1.7, the previous owner and developer of the site, yeah? Who actually owns the site now? Is it the applicant, Mr. McKee?
I understand it is the applicant who owns the site now, yes.
Okay, thank you.
Thanks, Councillor Thompson. Councillor Grimm.
This, the one that Ted's talking about, Carment Properties, were the Irish development company that bought it with a view to building flats along the front. But the houses that we're talking about have been there for over 200 years. Now that whole area is being refurbished, and the work that's being done there is tremendous. Absolutely first class. And I, for one, would really look forward to seeing these being reinstated, because it is such a picturesque area, and these will certainly enhance the whole village.
And in that way, are you proposing we accept the officer's recommendation?
Absolutely.
Okay, Councillor Driver and then Councillor Maitland.
Happy to second that, Chair.
Thanks, Councillor Driver. Councillor Maitland.
Yes. Again, the trouble is you look at the design of these and you think to yourself, they've been mucked up. I mean, really horrendously mucked up in terms of design, with the harling on them and the change of emphasis in those horizontal windows down below. And I just would have suggested to members that, in fact, actually, if we had insisted upon a bit more reinstatement of the more vertical emphasis of windows, you get a better looking development, which probably would last the course better. I know it sounds such a small thing, but in fact, actually, when something is what craftsmen call sweet in the eye, it tends to last longer and look better for a longer time. And I just wonder whether there was any debate with the owners with respect to doing that sort of thing.
I'll ask Mario on that, but then I'll ask David to come in as well. Maybe the opportunity to deal with windows would be at the time the application was being submitted or discussion being had with our staff, because, as I said earlier, we can't go about redesigning planning applications for agents, much as we would like to.
Obviously, in recommendation 2, that no development in respect to this plan shall take place unless details of the proposed external wall, roof finishing, and you could add in there windows.
Mary, have your go.
The application it's really just it's intended to reinstate what is there, and this is what was existing not so long ago. The details of the condition which is requiring details of the windows is really just to get the details of the type of windows we wish to install. It's not, I don't think we could insist under that condition that a different type of, different emphasis of window, a vertical emphasis of window.
I think as well, if you asked the 4 prospective tenants or purchasers to pick a window, they'd pick 4 different kinds. There's nothing surer, so it's maybe just, that's wrong, maybe wrong terminology that, but aye, so we maybe best leave it as and try and ensure that our case officers are sensitive when they're discussing finishings with clients. Councillor Gilroy.
Thank you, Chair. I don't want to rain on your parade, but we have SEPA objecting and our own council flood risk management team objecting, and Maria just said, it's more important to have the buildings occupied than to worry about flooding. I would suggest that if you were in the building when it flooded, you would wonder why on earth it was ever given permission to be occupied if it's prone to flooding. I think we have a duty to the people who live in these buildings that we make sure that we deal with the risk which is brought about to our attention by SEPA, which is a pity they're not here, 3 applications with them objecting and not a person here, which I'm disappointed at, but also our own council flood risk management team. So I think we're being a bit gung-ho here.
I think condition 1 addresses that, Patsy, but I think the other thing is we've already gung-hoed a permission for 37, including underground car parking. So this is simply allowing to be redeveloped buildings that have stood the test of time, and in as much as we can address it, we will. And we also always take into account other factors which come about a comprehensive decision, if you like. Councillor Ted Thompson.
Thank you, Chair. Just to address some of the issues raised by Councillor Gilroy. I mean, we've already determined applications, where SEPA have identified a 1 in 200 flood risk. And this application will, of course, have to go to, the Scottish Government for a decision, given that SEPA's a statutory consultee. Now, I think we've taken that decision on a number of occasions, and I think in this particular case, these houses have been inhabited for a number of years. The flood risk, in my view, is minimal, and the risk to the people inside is minimal. So I would suggest that we actually do go to the recommendation as they are.
Well, I think we're getting there, and I think members are entitled to air their views, and I'm happy to accept the view, advice, whatever you call it, the case officer in this case, and agree, but I'm open to members. We have a proposal that we accept this application. Are members satisfied that we do no dissenters? Unanimously agreed then that we notify Scottish Government of our intention. Item 50, look, Paula. Sorry, I've done it apparently. Item 15, formation of 1 wildlife pond retrospective at land south of Keswick Place, Annan. And the case officer is Lindsay Brown, and we're again notifying Scottish ministers of our intention to approve unconditionally.
Thank you, Chair. If you'd like to look at the location plan in your committee papers, then I'll take you through the slides. This first slide is the location plan showing the pond in relation to the B721 and into Eastridge Road and Keswick Place, also the railway line to the south and the Howgill Burn to the west. This is an aerial view which again shows the relationship of the pond to surrounding development and also shows the existing fishing pond which was formed in 2009 and which is directly to the west of the application site. This photograph has been taken from the edge of the B721, looking in a southerly direction towards the application site. Whilst the pond, which is subject to the application, cannot be seen, the existing fishing pond and the Howgill Burn can be seen towards the right-hand side of the photograph. Moving down into the field, this photo is taken again looking in the southerly direction. The pond, which is subject to this application, can be seen to the left, and the fishing pond formed in 2009 can be seen to the right. The Dumfries to Carlisle railway line lies beyond the two ponds, and the level of the track can be shown by the dashed blue line. This photo shows the pond, which is subject to the application, again with the railway line beyond, and again the level of the track shown by the dashed blue line. And this final photograph was taken by our planning inspector during construction of the pond and shows the general construction and the depth of the pond and also the relationship and the distance from the railway line, which is to the right of the photograph, beyond the fence line and the bushes. In conclusion, in terms of the principle of development and landscape and visual impact, the proposal is considered to be compliant with the terms of the development plan. In regard to flood risk, it's considered that there are material considerations of sufficient weight to justify a departure from the development plan in this instance, and therefore the application is recommended for approval subject to the notification to Scottish ministers.
Thanks, Lindsay. Again, there are no representatives, so we're in session. Councillor Dryborough.
It's maybe a silly boy question, this, but how do you get a flood risk in a pond?
It's free water.
I think it's where it goes if it happens to burst more than the pond itself, but I'm sure Lindsay will deal with that.
Yes, you're quite correct in that the risk is due to any rupture of the banks of the pond itself or any overtopping.
Actually, this is in my ward. I've seen it. I remember this being constructed at the time when Tesco's, at the same time as Tesco's was being built. I agree with the recommendations contained within the report in regards to this is only an improvement to the actual local area in regards to flooding. Tremendous amount of work undertaken with Scottish Water towards the Howgill Burn, which is it's just to the south or the west, the east side of what's been constructed here. Just in regards to the concerns that SEPA and the railway, ScotRail, whoever it is, have actually objected to this. I mean, I think they're big relevant points, but we've seen the pictures, the way it was constructed. I can remember it being constructed, I've seen it for myself, and I'm happy with the experience I've had in large scale developments like that, that it's been constructed in such a manner that it remains safe, and I think that is the issue. If there was a breach, would it have a detrimental effect on the ground below it, in particular the railway line? I think it's been constructed in such a manner. I'm certainly happy, and I've seen it being constructed at the time, and I think it's only a benefit. Now that it's in place, it's had quite a few tests in regards to water ingress and such like, so I think we're absolutely fine with this.
Thanks, Ian. I think somewhere in the report it says that SEPA are not comfortable with the lack of information. I think that's the problem rather than the construction type. But hey, Councillor Blake.
Yeah, I'm just a bit puzzled how we got to this position. You've got photographs from the planning inspector that shows the pond under construction. This is a pond that didn't have planning permission. And then there's photographs of showing it being completed. So presumably, despite the fact it didn't have planning permission, with a planning inspector there, the work still proceeded to its completion. Now it's going to retrospective. There seems a bit out of kilter there.
I don't think the plans came from a planning inspector. Did they not come from the applicant or the agent?
One of the photographs was taken by our planning inspector. The application was obviously partly or is fully retrospective, but it was brought to our attention during construction as part of the council's enforcement powers. Obviously, the planning inspector carries out an inspection of the site and thereafter contacts the landowner and the developer in order to seek a retrospective application. But obviously, as you've seen, the work's continued and therefore the application is fully retrospective.
I presume that explains it, because it's happened on a number of occasions recently when we bring to the attention of 80 individuals that what they're doing needs an application. It's only at that stage we receive it. So we were notified about it, we took matters in hand, and as a consequence, the report's here. I take it the man has gone on and concluded the works, irrespective of being advised that the planning application has been required. But again, we're not allowed to punish people for that. We have to determine it, whether or no it's retrospective or not, as the case may be. No. Councillor, oh sorry, did you want to finish, Councillor Blake?
Just, I can appreciate we're not here to punish. It was just the fact that I'm surprised we got to that stage, or that the developer went ahead at that stage.
I agree with you. Councillor McComb.
Thanks, Chair. Where does the outfall from the pond go?
The outfall from the pond is to the Howgill burn. It's detailed in the report. The inlet is from the existing pond, which is fed by the Howgill burn, but then again, the outfall leads back into that same burn.
Come back, Jim.
Please. I assume that information has been passed on to Network Rail, because they were concerned about the lack of detail with regard to the outfall.
Yes, all of the information that we had in respect of the application was available to all of the consultees.
Thanks, Jim. Any other member? Councillor McKee.
Hi, Chair. I'm back onto this Locker asking for planning permission. That's 2 ponds this guy's built and has not sought planning permission for either of them. They're treating the planning in this area with utter contempt, and there's got to be something we can do about it. Can I ask what the need is for this pond? There doesn't seem to be any need identified, or do we need to know a need?
No, I think it's as described. It's a wildlife pond. It seems to be an intention of the applicant to encourage particular types of wildlife. And the original pond is now out of date in terms of enforcement, so there's nothing we can do about it. And I know what you're saying, and we should be saying to officers at every opportunity, ensure that if enforcement is required, that enforcement is applied, and in that way it might get the message across to the wider community, because I'm quite sure in many cases when it's in innocence that these things are created or started, it just seems to be coming more in focus this particular meeting than normal. But we are where we are. We have an application. The original pond, it's finished, it's dealt with. It is a wildlife pond. The applicant wants to do that. Are we happy to endorse? Okay, that's Paula.
Committee is determined to notify Scottish Ministers of their intention to approve unconditionally.
Thank you. Item 16, formation of synthetic sports pitch, erection of 6 floodlighting columns, 15 metres high, and the 1.1 metre high spectator railings, amendment to planning permission 12/P/4/4/0107 at Langham Academy, Thomas Telford Road, Langham. It's full planning permission application, and case officer is Lindsay Brown, and we're asked to approve.
Thank you, Chair. If you'd like to look at the location plan in your committee papers, I'll take you through the photographs. This first photograph has been taken from the B709 Thomas Telford Road, looking east across the application site. This photograph has been taken prior to the commencement of construction on the new primary school, and the new synthetic pitch would be formed on the grass playing field in the centre of the photograph. This next photograph has been taken approximately from the same position as the last and shows the application site in relation to the new primary school, which is currently under construction. And this final photo is just a closer view of the application site. which would be located on the existing playing fields. This is simply a location plan showing the relationship of the application site to surrounding development, the River Esk, the new primary school, Langham Academy, and Thomas Telford Road. Proposed site plan shows the layout of the proposed synthetic pitch. This details the proposed spectator railings, which are 1.1 metres high. And this is the detail of the proposed 15-metre high floodlighting columns. And this final slide shows the light spillage from the proposed 6 floodlighting columns. And in conclusion, it was considered that the development was in accordance with the development plan, is therefore recommended for approval subject to conditions.
Thanks, Lindsay. I've got Councillor Dick and Councillor Driver, is it? Thank you.
Lindsay, I thought that this wasn't, but is it a 3G pitch?
I believe it is. It's certainly been described as a synthetic pitch. But,
Councillor Driver.
It depends on funding for Sport Scotland whether it's going to be 3G or not. So they're in discussions at the moment with Sport Scotland to have that. Chair, this is actually required in Langham because the Castle Home area is pretty flooded, and they're doing things like quaking and things like that to get rid of the flood in that particular area. It's an attachment to the new primary school. It's an all-through school. It'll have massive benefits in the local community, and I'm happy to go along with the recommendations.
Can I just say I'm jealous? Thanks, Lindsay. Okay, are members happy to approve this unanimously? Thank you, members. That's approved. Paula?
Committee is determined to approve the application subject to conditions.
Items 17 and 18 are decisions for noting the appeal decisions. They're there if you want to say anything about them. Otherwise, we will note their presence. Anyone happy with that? No other business. Thank you very much, ladies and gentlemen, for your attendance today. We'll see you on the 11th of December.